And I'm sure oh, there we go. And I'm sure oh, there we go. Okay, let me double check with headquarters.
Your Honor,
Yes, ma'am.
we have 2 students that are attempting to get in from our.
Yeah, that's my fault. I'm totally multitasking here. Sorry about that. Although I don't, oh, here we go. Who are the students trying to get in?
It should be Sandra Gavazzi and Paloma Yanez. Sandra's name might be Detective Booth, I'm not sure.
I don't show anyone attempting to get into the room. So I thought we had everybody. We don't? All right, let's deal with that in a second. Okay, guys, I don't see anybody else trying to get into the room. Do we not have everybody? I thought I asked that question. We don't?
I thought we had Detective Booth, but we don't. She's trying to log in right now.
Okay, well, as soon as she is able to, oh, no. I don't have anyone requesting to enter the room at this time. But as soon as she does, I will admit her. So interestingly, this is a little bit complicated because there are a lot of people talking to a lot of people at the same time. And that is part of the brave new world that you guys are stepping into for sure. And we are trying to acclimate to. So thanks for your patience up front. Hopefully we won't be too late getting going. And again, I still don't have anybody trying to enter the room.
I'm going to go help her.
Okay.
Okay, I believe she should be on the waiting list to get in.
Here we go. Thank you very much. Okay, so let's try that again. Prosecution, do you have all of your advocates and witnesses?
Yes, Your Honor.
Thank you. Defense, do you have all your advocates and witnesses?
Yes, Your Honor.
Perfect. We're doing well. All right, hang on. So while we're waiting, I just want to inform you that this is again, a little bit of uncharted territory. You guys are part of the Brave New World, and so part of it is that I'm gonna read a little bit from the script that the organizers give the judges, and then that'll sort of facilitate us moving into starting the round. Okay, so but I'll make it clear when I'm kind of given the company line, if you will, and then we'll move from there. Waiting for the all clear at this point. So I've been told that they're moving some jurors around. That's the delay. All right. So again, thanks for your patience. Hopefully the organizers are ironing it out here as we go. I think we'll be going here pretty quick.
Hey, Judge. I got to move Juror Don Anderson.
Yes, sir.
Don, can you hear me?
I can now.
All right. If you will just sign out and follow the same process that you got into this courtroom and go to courtroom 8, please.
Will do. Best of luck to everyone.
All right. I will be back. Stand by.
Yes, sir. Hi, everybody. It looks like we have all people here. It looks like we are cleared and ready to go. I've just received that. So with that very good news, welcome, a little bit late, but welcome nonetheless. We'll go ahead and call the case of State of West Carolina versus Timothy Ray. My name is Judge Pease. And scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means only the people in the screen right now should be the advocates and me. So I think that actually is to me. I'm not sure I know how to do that.
Mr. Peace, if you go next to start video, the little arrow,
Yes,
and then you go to video settings,
perfect. I'm following.
and then you want to hit hide non-video participants.
Awesome. Thank you very
You're
much.
welcome.
Very helpful. Appreciate that. Excellent. All right. So at this point, I just want to make another couple of quick announcements for court purposes. We'll do, with permission of the advocates, we'll do time checks at mid-trial and also just prior to closing statements. And I'm going to allow the timekeepers to make their presence known and even up to and including provide countdown if necessary, okay? And I'll let the advocates decide if they want to do that. But whatever we do, we'll do it fair across the board for everyone, all right? And if we have the luxury of the time, I'll also want to provide a couple of quick breaks at mid-trial and also maybe just prior to closing arguments, again, with as long as it is copacetic with counsel. And as we end the trial, we'll move through ballots and do the administrative piece with the scoring judges, and then we'll wait here and stand by for the all clear. And once we are provided that, we'll give the scoring judges and myself an opportunity to give very, very brief feedback to you guys, okay? So with that, can the attorneys please make appearances?
Good morning, Your Honor. Or sorry, good afternoon, Your Honor. My name is Daisy Wilkinson, and along with my co-counsel, Brianna Brill, we represent the people of West Carolina today. Would you like a statement of the case, Your Honor?
Not yet. Thanks, Daisy. I'm gonna actually just have introductions at this point, and we'll have introductions from defense as well, please, and then we'll get into some housekeeping, okay?
Yes, good afternoon, Your Honor. My name is Avery Hitchcock, appearing on behalf of the defendant, Timothy Ray. Today I'm joined by my co-counsel, Mr. Blake Barrich.
Good afternoon, Your Honor. Blake Barrich on behalf of the defense.
Hi, Mr. Barrich. Thank you very much. And does the state have any housekeeping items at this time?
We do, Your Honor.
Great.
Your Honor, may we move about the courtroom as long as we are within the Zoom screen?
You may.
May we use an exhibit during our opening statement?
Opposing counsel, you have any comment about that?
Yes, Your Honor, but this may be better served in motions in limine. We have no objection to the use of exhibits that will later on be entered into evidence. However, we have met and conferred, and we are aware of one exhibit that we do not believe is admissible, and as such, we'd like to argue the admissibility of that before it's used.
Thank you very much, Mr. Hitchcock. We'll get to that. But is there any, if I understand you correctly, it's really a substantive matter. You don't care necessarily that there is some sort of demonstrative use, that which demonstrative you may have an issue with. So we'll cover that in substantive matters. Is that fair, Ms. Wilkinson? If we can just leave it at that for the moment, that there's no objection to the demonstrative, but which demonstrative we'll cover in just a minute in substantive matters. Is that fine? Is that fine with you?
Yes, Your Honor.
Oh, I'm sorry, Ms. Brill.
Yes.
Thank
but
you.
yes,
Thank
fair.
you. Thank you.
Your Honor, we plan on calling an expert witness in our case in chief. Would you like us to lay foundation and then formally tenure them as an expert, or just lay foundation and then continue on with the
Brill,
exam?
I'm gonna hold on that for a minute because we're still in housekeeping. I want to make sure that defense doesn't have any housekeeping. Does the prosecution have any other housekeeping matters?
Yes, Your Honor.
Okay, that are not substantive. I want to get into motions, but not quite yet.
Your Honor, may we assume that all witnesses are constructively sworn?
Great idea. I think that's fantastic. Yes.
Your Honor, I'm not sure if you would consider this substantive, but as you are aware, we're having today's trial via Zoom. Because of that, would you like us to lay foundation for exhibits and then publish, or publish while we're laying foundation?
So are there any pre-admitted exhibits or any exhibits you guys want to pre-admit from negotiations prior to trial?
No, I don't think so, Your Honor.
Okay, I take it not. Then we'll have foundation then prior to receiving evidence. Okay.
Yes, Your Honor. The rest of our issues are substantive.
Fantastic. So how about the defense? Is there any housekeeping matters for defense?
Your Honor, just that we asked for constructive sidebars, considering we're in a Zoom courtroom and it's impossible to actually approach the bench, that all sidebars are constructively heard outside the earshot of the jury.
We'll constructively keep 6 feet apart at all times electronically. And meanwhile, we'll also ensure that all witnesses are constructively sworn as previously noted. Any other items?
Just one, Your Honor. All exhibits in this case have been pre-marked as joint exhibits, and we ask that they just retain these numberings regardless of the order in which they're received.
Assuming no objection from opposing counsel, that seems efficient to me. Is that okay with opposing counsel?
Yes, Your Honor.
Fantastic. We're in wild agreement. I love it. So does that take care of all pretrial matters or all housekeeping matters? Are we ready to talk about any motions at this time? So
It does, Your Honor.
Let's hear from prosecution if there's any motions now.
Your Honor, would you like to review the substantive matters first before going into motions?
Sure, that's fine.
As I said before, we plan on calling an expert witness. Would you like us to formally tender them, or just lay the foundation and continue on with the examination?
I think I'd like to have them tendered.
And then, Your Honor, in reference to the pretrial orders listed on page 4 of the electronic notebook, we want to specifically make the court aware of order number 9. This order states that the state is not permitted to present any rebuttal witnesses. The state must call its witness in its case in chief. The defendant may not object to the state calling Dr. McLaGreca in its case in chief to testify about the insanity defense on the grounds that the defendant has not yet presented evidence of the insanity defense. The court reserves all of the rulings regarding Dr. LaGreca's testimony for trial.
Bear with me 1 second. I think, counsel, if you can direct me to the page.
It's on page 4, Your Honor.
Thank you. Yeah, and I think you're mentioning step 9. Is that what we're talking about here?
Yes,
yeah. Defense, do you have any comment? I'll hear any comment you may have at this time about step 9.
No, Your Honor. Since it's stipulated, we definitely would not be objecting to calling Dr. LaGreca in the case in chief. That's the rules of this jurisdiction. So
I tend to agree. So with that, we're all, again, in wild agreement. It's fantastic when it works out like that. Great. Step 9. Got it.
Perfect. Your Honor, at this time, the state has 2 motions in limine.
Okay, sure. We'll hear the motion. Just a quick thing, because we looked at some other matters. Is there any matters other than motion in limine from the defense at this time?
No, just motions in limine.
Okay, we'll hold that just for a second. We'll let the state go first with motion in limine. Thank you.
Your Honor, pursuant to Federal Evidence 704B, the state moves to bar the last 2 opinions of the defense's expert witness in this case, Major Riley. Would Your Honor like some background?
I'll very briefly.
Your Honor, we have reason to believe that the defense will bring an insanity defense in this case. And as part of proving that defense, they have to prove the defendant was unable to appreciate the wrongfulness or quality of his actions, and that he did not act with malice aforethought. Your Honor, in the last 2 opinions of the defense's expert witness, they stated that the defendant did not act with malice aforethought and that he was unable to understand the wrongfulness of his acts. This goes directly to the ultimate issue and should be barred pursuant to Federal Evidence 704B.
Defense?
Yes, Your Honor. Dr. Riley wrote her expert report without necessarily keeping the federal rules of evidence in mind. As such, since she'll be testifying today and under the federal rules of evidence, she'll be giving testimony in line with the federal rules of evidence. Won't be going over 704 issues. I don't anticipate that being a problem from our end or from the state's end with the Dr. LaGreca expert. So we have no objections to that.
Thank you, Mr. Hitchcock. Ms. Brill, does this rule specifically bar that such testimony from an expert witness?
Yes, Your Honor, and it also aligns with the case law in this jurisdiction, specifically Pastoreo v. West Carolina, which states that an expert witness cannot testify to the ultimate issue, which in insanity defense cases goes to the defendant's mental state and inability to appreciate the wrongfulness of his conduct.
So that's an interesting argument. I think I want to let Mr. Hitchcock have one more bite at the apple, and then I'll make my ruling, okay?
Your Honor, we won't be going into the defendant's subjective mental state. No expert will be offering an opinion about whether he knew the difference between right and wrong at the time that Nathan Ray was killed. However, Pasquarello does continue on to say that while an expert can testify to the characteristics of a disease and opine as to whether that defendant had the disease at the time of the alleged criminal act, this testimony is well within the bounds of 704 and will be offered because it doesn't offend the ultimate issue. It isn't going to the defendant's subjective state of mind at the time the act occurred.
Ms. Brill, I'm inclined to agree. And I think with your careful, acute awareness and sharp lookout, I'm sure that you'll ensure that opposing counsel does not allow the witness to testify upon the ultimate issue, which essentially is outside the bounds of the medical or pathological condition of the patient at the time of the review. And so therefore, I think as long as we stay clear of things along the line of the defendant was aware that was not aware that his acts were unlawful, or that his acts were somehow that he was going to avoid criminal prosecution due to his pathology. I think as long as we stay clear of that, we should be okay. Do you agree?
Yes, Your Honor.
Fantastic. Are there any other motions from prosecution?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 701 and 602, we are moving to exclude any testimony that Officer Wentz may give regarding a lay opinion about the defendant's mental health. We have reason to believe that Officer Wentz will opine on the defendant's mental state at the time he was arrested. Any opinion that he would give on the defendant's mental health would lack personal knowledge, as Officer Wentz has no way of knowing what was going on in the defendant's mind. And additionally, he's not an expert on mental health. Specifically, Your Honor, we're asking to bar him from saying things such as the defendant was acting crazy, he was having delusions, he was paranoid, phrases of that nature, Your Honor.
Defense?
Your Honor, Officer Wentz was on the scene, and as a lay witness will be able to testify to the observations that he made about the defendant that night. Because he was present and he was there, he'll be able to testify, giving lay opinions about whether or not, what sorts of behaviors that he observed, what his demeanor was, how he was responsive to questions. I don't anticipate Officer Wentz diving into the defendant's specific mental state about whether there were delusions or hallucinations or whatever they may be. And we agree, Officer Wentz is not an expert in mental health. But as a police officer who was available at the scene, he should be allowed to give his perceptions about how the defendant was behaving as a lay individual, because that does go towards his mental health.
Understood. Ms. Wilkinson, any last bite at the apple there, quickly?
Your Honor, we're totally okay with him opining on his observations. Just specifically, though, we just don't want to get into his actual mental state, as they do have an expert who will be testifying on the medical terminology relating to that mental state.
Sure, and the court is on notice of that fact. Thank you, Ms. Wilkinson. I think that with your, again, acute listening skills and close listening skills, I'm sure you'll ensure counsel does not breach that line of demarcation. And if he does, I'll look forward to hearing your objection at that time. So with that, are there any other motions?
Your Honor, we would just like to address the exhibits being used in the opening statement. We will be using Exhibit 29, which is on page 106 of the electronic notebook,
Okay.
and Exhibit 19, which is on page 96 of the electronic notebook.
And thank you for bearing with me as I look these up. Okay, you want to use these demonstratives during open? Is that what I understand?
Yes, Your Honor.
Is there objection from defense?
Your Honor, we have no objection to the use of Exhibit 29 during opening. However, we do object to the use of Exhibit 19. Exhibit 19 on page 96, are we assuming that these are being heard outside the earshot of the jury?
We are, yes.
Your Honor, this photograph depicts Nathan Ray's body in a body bag in the park where he was buried. Considering the facts of today's case and that we aren't disputing that Timothy Ray did in fact kill Nathan Ray, This makes no fact at issue more or less likely, and instead is only being used to inflame the passions of the jury. This is textbook evidence that is typically excluded under Rule 403 in cases like this, and as a result, we object to its use in opening, since we would object to it when it would be offered in Detective Booth's testimony.
Ms. Brill?
Your Honor, this evidence is being offered to rebut the affirmative defense that the defense is bringing in this case. As I said before in motions, in order to prove that defense, they have to prove that the defendant was unable to appreciate the wrongfulness of his conduct. However, Your Honor, it's our theory that the defendant did understand the wrongfulness of his conduct, and it's evidenced in what he did after the murder occurred. Your Honor, this picture demonstrates one of the actions the defendant took after the murder occurred, which is our argument to rebut that affirmative defense that he was unable to understand the wrongfulness of his conduct.
Mr. Hitchcock, I'm going to sustain your objection in part and overrule it in part to the degree that I'm going to exclude Exhibit 19. Ms. Brill, I have every confidence in your deft advocacy skills that you will be able to make the point regarding the actions of the defendant at the time of the relevant time without use of this particular picture. It is my view that this picture tends to be more injurious. It's more likely to inflame the jury than it is to provide probative evidence to indicate that that's dispositive of the defendant's actions. So again, I'm going to disallow 19 and allow exhibit. Forgive me, what was the first one, counsel?
Exhibit 29.
24.
29.
29, thank you, sir. Exhibit 29 is, if I recall, just a picture of the child. Is that correct?
Yes, Your Honor.
Great. So we'll allow the picture of the child in, but we're not going to allow the gruesome picture in. Okay?
Your Honor, if I may briefly be
Sure.
heard. Your Honor, this is not a gruesome picture. You can't see the actual body in the trash bag. And it's incredibly important for the members of the jury to know exactly what the defendant did after the crime occurred. This is the only picture that we are offering into evidence that shows the black trash bag. It's not cumulative. It will not inflame the emotions of the jury. It's just essential to establish not only the timeline, but what exactly the defendant did after the crime.
Ms. Brill, your objection's noted. I've made my ruling. Okay, so let's move on. So are there any other motions in limine from the prosecution?
No, Your Honor.
Thank you very much. For the defense, there are any motions in limine?
Yes, Your Honor. We have one motion in limine to be heard today.
Great.
Specifically, we move for the pretrial admission of Exhibit 15. For Your Honor's reference, this is on page 78 of the electronic notebook. And it's a deposition transcript, a pretrial deposition transcript of Dr. Sam D. Giuseppe, a doctor of Timothy Ray's, who he sees various times between 2010 and 2019, who's unavailable for testimony today. Both parties stipulate that this is authentic. Both parties stipulate that she is unavailable. And at this deposition, both parties were present and given the full and fair opportunity to examine this witness, knowing that she would be unavailable for trial today. Therefore, this is not an exception to hearsay under former testimony, Rule 804B1, and we move for its admission at this time since we will be referencing it throughout trial today.
Prosecution?
Your Honor, we object to this not being relevant and also substantially more prejudicial than it is probative. Starting with the relevance objection, this doctor has not seen the defendant recently or even after the crime occurred. And further, the defendant never reported any symptoms of schizophrenia to this doctor, which is the mental disease that the defense is claiming the defendant have. And more importantly, this doctor is only a general care physician, not a psychiatrist or a psychologist. It's out of her purview to even recognize the symptoms of a mental illness and to diagnose that mental illness. Your Honor, this is also substantially more prejudicial than it is probative, and it runs the risk of confusing the jury. The defense is presenting this testimony as something given by a doctor. However, this is, again, a general care physician, not a psychiatrist, and it runs the risk of confusing the members of the jury that this doctor was able to treat mental health issues.
Mr. Hitchcock?
I'll start with the relevance point, Your Honor. In terms of relevance, this document is clearly relevant because the case comes down today to Mr. Ray's mental health. A doctor who evaluated Mr. Ray saw him on multiple
Mr.
occasions.
Mr. Hitchcock, I'm going to interrupt you just for a second and ask you, I understand your argument I understand your 401 argument, but I want to understand more clearly, how is this particular exhibit of quote consequence to determining your action here?
Your Honor, if I may, our theory of the case today is that Mr. Ray slipped through the cracks of the medical system, that he had been exhibiting signs of schizophrenia, signs that were noted in Dr. DiGiuseppe's testimony, but that he was never diagnosed. As a result, the doctors missed the signs and Mr. Ray's schizophrenia got worse, regardless of whether—
Mr. Hitchcock, is this doctor in a position to make such a diagnosis? If your argument is that if your argument turns on whether or not this particular defendant should have been diagnosed with schizophrenia, is this particular physician actually in a position to make such a diagnosis? And if so, and if not, how is that consequential to determining your action?
Your Honor, all medical professionals, when they're in medical school, receive training on how to recognize the signs and symptoms of mental illness so they know how to deal with those individuals, regardless of what field of medicine that they're practicing in. So regardless of whether you're a general practitioner, you're working in the ER, or whatever it may be, you take these courses to learn about what the signs and symptoms of mental illness are. Even if it isn't part of their regular practice to be diagnosing individuals with mental illness, Dr. DiGiuseppe, like all medical professionals in this country, has the training needed to recognize the signs of it, and in fact did recognize the signs of it by referring Mr. Ray to a psychiatrist in 2017. As a result, it definitely is probative to the fact of Mr. Ray's mental state, and Dr. DiGiuseppe is able to give that opinion.
Understand. And Mr. Hitchcock, a valiant effort, sir, and an excellent argument. However, I am not persuaded. We're not going to let 15 in. I feel it's too attenuated. There are already experts that are going to deliver that testimony exactly, in fact, that are theoretically going to be proffered as experts and at least are certainly not family practice physicians, but yet are specialists in the area of psychiatry. So I'm sure that you will have every opportunity to make your case with that type of evidence coming in under those witnesses. Fair enough?
Yes, Your Honor.
Thank you, sir. Are there any other motions of limine from the defense?
That was our only one. We're ready to proceed to openings.
Great. And with that, let's have opening statements from the prosecution, please. And you may proceed when you're ready, Ms. Wilkinson.
Yes, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury. This was Nathan Ray, a young boy who attended Skelton Elementary School and was a Carolina Panthers fan, a 6-year-old child who liked to play soccer and who loved to play with his choo-choo train, the Nathan Express. Unfortunately, you won't get to meet Nathan today. Why? Because his father, the defendant, strangled him to death on October 17th, 2018. Members of the jury, you will learn that the defendant put vengeance against his wife over the value of his son's life. Good afternoon. My name is Daisy Wilkinson, and along with my co-counsel, Brianna Brill, we represent the people of West Carolina. Members of the jury, a parent is supposed to protect their child from harm, not create it. A parent is supposed to give life, not take it away. But that's not what the defendant did. The evidence will show that the defendant took the life of his only child when he punished him, strangled him, and murdered him. You're going to hear about the defendant's heinous actions today. We will call Detective Blake Booth, the lead homicide detective who investigated the murder of little Nathan. Now, pay attention to his testimony, ladies and gentlemen, because he's going to tell you the exact steps the defendant took to plot, strangle, and kill his son. Started off like any other day. That morning, little Nathan was having a bowl of cereal and some apple juice. And right before it was time for him to head off to school, Nathan accidentally spilled his juice. And the defendant became enraged. Now, I want to be very clear about something, ladies and gentlemen. The defendant wasn't upset because his son spilled some apple juice. No. The defendant was upset for reasons that had nothing to do with little Nathan. You see, the defendant had just learned that not only was his wife cheating on him, but she had left him. And the defendant was afraid that she was going to take Nathan away from him. So in this moment, fueled by anger and resentment, the defendant took out his frustrations on his innocent son. Members of the jury, you're going to hear how the defendant punished Nathan by making him do extreme and exhausting military exercises until Nathan was crying and screaming in pain. That wasn't enough for the defendant. He needed to do more. So the defendant then went to his room. He sat on his bed and he thought about exactly how he was going to get back at his cheating wife. So the defendant got a belt and he went back into Nathan's room and he started beating his son, whipping him with that belt over and over. But once again, that wasn't enough. You will hear, ladies and gentlemen, in the defendant's own words, the next steps he took. I put the belt around his neck. I pulled the belt until he stopped screaming, until he stopped moving. Ladies and gentlemen, the defendant watched his own son struggle, gasping for air, as he pulled the belt tighter and tighter until Nathan was dead. Members of the jury, the defendant confessed to killing his own son. And if that wasn't enough, you are going to hear how the defendant tried to cover up his heinous crime. The defendant put his son's body in a trash bag. He drove around with the corpse in his car and then dumped it like he was throwing out a piece of trash. Ladies and gentlemen, the evidence will show that this wasn't some accident committed by an ill man. This was cold-blooded killing committed by a murderer. And we will prove to you today that on October 17th, 2018, the defendant intentionally killed his 6-year-old son, Nathan Ray. And at the end of this trial, my co-counsel, Brianna Brill, will come back before you. And she's going to ask you to return a verdict that tells the defendant he can't hide behind any excuses, that there is no justification for killing your own son. A verdict that tells little Nathan Ray that his life was worth more than the defendant's desire to get back at his wife. Return a verdict of guilty.
Thank you very much, Ms. Wilkinson. We'll have the defenses open now, please. And Mr. Veitch, you may proceed when you're ready. Okay.
They missed the signs. Timothy Ray is sitting in a doctor's office. He's been there before. The same curtain in the corner, the same clock on the wall, the time frozen in place. He keeps coming back because he knows something is wrong. Something has always been wrong with him. He tells the doctor, "I've never been okay." But instead of getting the help he needs then, Mr. Ray is allowed to leave. He never gets any medication. He never gets any help. He leaves that doctor's office like every time before, untreated. Now, members of the jury, what happened on October 17th, 2018 was terrible. A parent's worst nightmare. And to think that a parent could do this, it's unimaginable. No normal person would. But today, you're going to hear evidence that'll show that Timothy Ray wasn't normal. He's sick. Very, very sick. He was suffering from schizophrenia. But the doctors, his family, his friends, they missed the signs. Because of this, we're bringing what's known as an affirmative defense, which means it's our burden to prove to you by clear and convincing evidence that Mr. Ray was legally insane. Now, what does that mean? Put simply, it means that when he killed his son, Mr. Ray didn't realize what he was doing was wrong. We'll prove this to you today by showing you two simple facts. Number one, Mr. Ray was suffering from schizophrenia, a terrible mental illness which makes people hear voices not their own and have delusions that just simply aren't true. Number two, we'll prove that this schizophrenia took control and caused Mr. Ray to harm his son. First, the evidence will show that Mr. Ray was suffering from schizophrenia years before any of this happened. It was never diagnosed. You're going to hear from Dr. Shane Riley, a board-certified expert in forensic psychiatry. She'll testify that she reviewed Mr. Ray's history, did an in-person evaluation, and made a diagnosis. Mr. Ray had a family history of mental illness. He suffered from childhood trauma. Mr. Ray saw hallucinations. He heard voices in the years before October 2018. Mr. Ray had delusions about his wife's affair. And perhaps most importantly, the evidence will show that the people around Mr. Ray saw him acting in stranger and stranger ways as the years went on. You'll learn that his wife saw him go through constant mood swings and that he got more and more isolated. Now, you just heard a story about a cover-up. But Dr. Riley will explain her thorough evaluation and this third-party corroboration led her to conclude that Mr. Ray was suffering from schizophrenia years before October 2018. That it got worse and worse, but everyone missed the signs. Second, we'll prove that at the time of his son's death, Mr. Ray was experiencing a schizophrenic break. He had delusions about his son and wife conspiring against him. He heard voices telling him over and over he had to kill his son. The evidence will show that Mr. Ray was still sick when the police found him. You'll hear that after his son's death, Officer Wentz stopped Mr. Ray at what was supposed to be a routine checkpoint. You'll hear it was anything but routine. You'll hear that Mr. Ray started screaming these accusations of being CIA in one moment, and then in the next was silent, the blank stare. You'll learn this was schizophrenic behavior. But the evidence will show this behavior was ignored by both prosecution witnesses. You'll learn that after Detective Booth interrogated Mr. Ray, the detective said, "You're a piece of shit, would be better off dead." And then allowed the only footage of that interrogation to be wiped clean. You'll learn that the prosecution's expert apparently didn't need to see this footage, didn't need to interview Mr. Ray or anyone else. The evidence will show the prosecution had their minds made up. They missed the signs, they even ignored them. But you don't have to. Now, to be clear, Mr. Ray will regret October 17th, 2018 for the rest of his life. He was a father, and he lost a son forever. But the prosecution will try to say he knew exactly what he was doing. He knew it was wrong. The evidence will show that Mr. Ray isn't evil. He's sick. At the end of today's trial, my co-counsel Avery Hitchcock will ask you to find Mr. Ray not guilty. Thank you.
Thank you very much, counsel. Is the prosecution ready to proceed?
Yes, Your Honor. The prosecution calls Detective Booth to the stand.
Detective Booth, you're going to be constructively sworn. Good afternoon. And Ms. Brill, you may begin your examination when you're ready.
Good afternoon. Please introduce yourself to the members of the jury.
Good afternoon. My name is Detective Blake Booth. For the record, last name Booth.
What do you do for a living?
I am a detective at the Skelton Police Department, badge number 3681.
How long have you been employed at the Skelton Police Department?
For a total of 23 years now.
How long have you been a detective?
7 years.
Could you describe your progression through the Skelton Police Department?
Sure, absolutely. So I started in 1997. That's when I was a patrol officer for the Gang Violence and Narcotics Unit. Then at that point, I believe it was 2012, I got promoted to detective in that unit. And then come 2017, I was promoted to the homicide unit as a detective. And that's where I currently am now.
Detective, what kind of responsibilities does a homicide detective entail?
Well, I investigate homicide cases, murder cases, and in fact, I do most of the work. I do everything from interviewing the suspects and the witnesses, and then I do everything else from investigating the crime scene and collecting evidence. I've investigated 12 homicide cases at this point.
Thank you, Detective. Were you a homicide detective in October of 2018?
Yes, I was.
I'd like to turn your attention to October 18, 2018. Do you recall receiving a phone call that day about a missing child?
Yes, I do.
Who was that missing child?
That was Nathan Ray.
Were you then assigned to investigate the whereabouts of Nathan Ray?
Yes.
What was the result of that investigation?
Well, the defendant, Timothy Ray, confessed to killing his son on October 17th, 2018.
Do you see the defendant in this courtroom today?
I do, yes.
Can you identify the defendant by an article of clothing they are wearing?
Sure, he's wearing a white shirt and a red tie, and his Zoom name is Defendant Timothy Ray.
Your Honor, let the record reflect the in-court identification of the defendant.
The record shall reflect. Thank you.
Detective, I want to start at the very beginning of your investigation. Around what time did you receive that phone call about Nathan?
It was about 4:05 in the afternoon on the 18th.
Who called you?
Jessica Ray, Nathan's mother.
What did Jessica tell you?
She told me that afternoon she had tried to go to Skelton Elementary School to pick up her son, but he wasn't there.
What, if anything, did Jessica do when she realized her son was missing from school?
Well, she immediately went to the teacher to ask where her son was, and the teacher mentioned that, in fact, Nathan hadn't been in the class for the past 2 days.
Did you learn who the last person Nathan was with before he went missing?
Yeah, he was last seen with the defendant on the 16th.
Did Jessica then try to contact Nathan's father?
She did, yes. She tried to call him multiple times, and then she eventually just went over to his house.
What happened once Jessica arrived at the defendant's home?
Well, the defendant wasn't there, and neither was her son.
Detective, did Timothy Ray become a suspect at this point in your investigation of Nathan's disappearance?
Oh, absolutely.
Did you ask Jessica for any information about the defendant in order to locate him?
I did, yes. And she provided me with a physical description of him, as well as a contact number, an address, and then also a description of his vehicle.
Did Jessica provide you a description of Nathan as well?
She did, yes. She told me that he was a white male. He was about 3'9", 45 pounds. He had green eyes and light brown hair. She additionally said that he was last seen wearing a red shirt, blue pants, and a Carolina Panthers zip-up hoodie. She additionally provided me a photo of him.
For the record, directing everyone's attention to what's been previously marked as Exhibit 29, page 106, for identification purposes. Detective, do you recognize Exhibit 29?
Yes, I do.
What is it?
It's a photo of Nathan Ray that Jessica gave me.
Is this a true and accurate copy of a photo of the victim in this case, Nathan Ray?
Yes, it is.
Your Honor, permission to admit Exhibit 29 into evidence?
Counsel, I think we had it admitted at pretrial, but you're free to publish if you'd like.
Thank you, Your Honor. Detective, taking a look at Exhibit 29, does this accurately depict what Nathan Ray looked like in October of 2018?
It absolutely does.
After you spoke with Nathan's mother, what did you do next in your investigation?
Well, I wrote a missing persons report for Nathan. I included a description of him as well as the defendant.
Did you receive a response to the missing persons alert you issued?
I did. Actually, the very next day, I got a call that the suspect labeled in my missing persons report was stopped at a sobriety checkpoint in Skelton, right outside Skelton, actually.
Let's turn to October 19, 2018 then. Around what time did you receive this call about a suspect?
About 9 p.m.
And once you received this call, what did you do?
Well, I immediately drove down to the checkpoint 22 sobriety checkpoint, and again, that's right outside Skelton.
What happened once you arrived at the checkpoint?
I spoke with Officer Wentz, but I already had noticed that the defendant was sitting in handcuffs on the side of the road, as well as his car was on the side of the road.
What did you and Officer Wentz speak about?
Well, he told me that he had run the defendant's license plate, and at that point, that's how he found out that he was wanted in my missing persons report.
Did Officer Wentz tell you anything else?
Yes, actually, he told me that he saw in the back seat of the defendant's vehicle a shovel with a red liquid on it. He said there was 2 bottles of bleach and there was trash bags.
Now, based on that information, what did you do next?
Well, I had the car impounded and then I later searched the vehicle.
Did you recover anything from the defendant's vehicle?
I did. I recovered all the items that Officer Wentz mentioned. So the shovel, the 2 bottles of bleach, and as well the trash bags. I also took pictures of them for evidence and inventory purposes.
Detective, going back to the night of October 19, 2018, after you spoke with Officer Wentz on scene, what did you do next?
I told the defendant that we were going to take him down to the station for an interview.
Did the defendant say anything to you at this point?
Yeah, he did. He told me that he completely understood what I was saying and that he wanted to tell me everything. So
What happened once the defendant arrived at the station?
we placed him in an interview room.
Did you then question the defendant?
I did.
Detective, prior to questioning the defendant, did you advise him of his rights?
Absolutely, I do that with everyone. I read him his rights and then I gave him the paper. He read the paper and then he signed next to each Miranda right, stating that he understood and wished to waive his rights.
And after he signed the Miranda form, is that when you questioned the defendant?
Yes.
What did the defendant tell you during that interview?
Well, he told me that Nathan was eating breakfast at his house that morning and that Nathan spilled apple juice on his computer. And then he said he yelled and punished Nathan.
How did the defendant punish Nathan?
Well, he forced Nathan to do military-style exercises, something that no kid should have to do. And
Objection,
then
improper opinion.
Ms. Brill?
Your Honor, this is not an improper opinion. Detective Booth is testifying to what the defendant told her during that interview.
Your Honor, if I may, the detective just gave her own opinion about whether or not a child should have to do these types of exercises. That's not for the detective to discuss.
Ms. Brill, last chance.
Your Honor, aside from that statement, the rest of her testimony is within her purview to testify about.
Understand. I'm going to sustain the objection. Counsel, would you care to have the testimony struck?
Yes, Your Honor.
All right, the testimony will be struck with the exception of just that part. And to Ms. Brill's point, the rest of it will remain. Fair enough?
Fair enough.
Great, thank you.
Detective, after the defendant told you he punished Nathan, what did he say he did next?
Well, Nathan was crying and screaming, so he stopped doing the exercises, and then the defendant punished him even more.
How so?
Well, the defendant said that he went into his bedroom, he sat on his bed, and then he got a belt from his closet and then went back and hit Nathan multiple times with the belt.
Where did this occur?
It was in Nathan's room.
Detective, after the defendant hit Nathan multiple times with a belt, what did he do next?
Well, at that point, Nathan just kept crying and crying, so the defendant told him to shut up. And then Nathan just kept crying, so the defendant put a belt around his neck, and then he tightened the belt until his child stopped screaming.
Did Nathan stop screaming?
Yes, the defendant said that he stopped moving completely.
Detective, did the defendant admit to killing his son?
Yes, he did.
Did you learn what the defendant did with Nathan's body after the murder?
Yes, he put him in a trash bag, put him in his car, and then he drove around with him for a few days. And then at that point, he dumped him in Brandywine State Park.
Did you search Brandywine State Park for Nathan's body?
Yes, myself and a search team, we went and searched Brandywine, and we did recover the black trash bag.
When you recovered this black trash bag, did you find anything inside?
Yes, unfortunately, we did find the body of Nathan Ray.
Once Nathan's body was recovered, where was it taken?
We took it to the medical examiner's office, and then an autopsy was conducted on the 22nd of October.
Did you review the results of this autopsy?
Yes, I did.
What were the results?
The medical examiner concluded that Nathan Ray died by homicide, and specifically that he died because of strangulation.
Detective, I want to now focus on your investigation after Nathan's body was recovered. Did you find any other evidence during your investigation?
Objection vague.
Why is it vague?
Your Honor, did you find any other evidence in this investigation is an incredibly broad question. It should be more narrowly focused. Obviously, there's plenty of different pieces of evidence from examining the scene, examining where the body was recovered. It should be rephrased to be more specific as to what opposing counsel is trying to get at.
Ms. Brill, would you mind rephrasing your question?
Sure, Your Honor.
Thank you.
Detective, during your investigation, did you conduct a search of the defendant's items?
I did, yes.
Did you recover any evidence from those items?
I did. I recovered a cell phone, the defendant's cell phone, actually.
And who specifically recovered the cell phone?
The Skelton Police Department.
And once the phone was recovered, were you able to confirm that it was the defendant's phone?
Well, yes, when we opened the phone, Timothy Ray's Apple ID was connected to the phone. I mean, right inside it said Timothy Ray.
And once the phone was recovered from his items, where was it taken?
We took it for a forensic analysis.
Did that forensic analysis reveal anything?
It did, yes. It revealed 3 Google searches, which were conducted by the defendant on October 18th, 2018.
For the record, directing everyone's attention to what's been previously marked as Exhibit 10, page 57, for identification purposes. Detective, do you recognize Exhibit 10?
Yes, I do.
What is it?
These are the screenshots of the defendant's phone.
When were these screenshots taken?
October 22nd, 2018.
Is this a true and accurate copy of the screenshots taken of the defendant's phone on October 22nd, 2018?
Yes, it is.
Your Honor, permission to admit Exhibit 10 into evidence?
Any objection?
Yes, Your Honor, we object under Rule 403. May I be heard?
May.
Your Honor, these Google searches the prosecution is trying to admit are not from the same day that Nathan Ray died. They're from a full day after. The prosecution has to prove that Mr. Ray was not legally insane, that he premeditated this act before killing Nathan Ray. And our burden is also concerned with one specific time period, the time where Nathan Ray died. These Google searches, all they show is Mr. Ray's rationale a day after Nathan died. And since they don't go to a specific state of mind at the time in question, admitting them to show his state of mind the day before would unfairly prejudice the defendant.
Ms. Brill.
Your Honor, that's exactly why they're probative. This is essential to rebut the affirmative defense in this case, where the defense has to prove that the defendant was unable to appreciate the wrongfulness of his acts. Your Honor, these searches were conducted the day after he killed his son and are incredibly probative in rebutting the affirmative defense to show that the defendant understood that his acts were wrong.
Last bite at the apple, Mr. Hitchcock.
Your Honor, regardless of whether or not the defendant understood that his acts were wrong the next day, that has no bearing on his mental state the day that he actually killed his son, which is the time in question here. It doesn't matter whether or not he realized his acts were wrong, because this isn't a case about evidence tampering or aiding and abetting the commission of a crime. This is about the murder itself. And the murder itself happened on October 17th, not October 18th.
Your Honor, if I may be heard briefly.
Last chance.
Your Honor, it's the defense's position that the defendant had schizophrenia since he was 10 years old. They are establishing for the members of the jury that this is a disease that he had his entire life that went untreated. Therefore, it doesn't go away the day after a crime is committed. If he really has this mental disease, it's something he'll have for the rest of his life. Therefore, this is relevant evidence.
Mr. Hitchcock.
Your Honor, just because somebody is afflicted with a disease doesn't mean that they're always experiencing symptoms from that disease. We're living in a pandemic right now where some people have a disease, a very terrible disease, but not all people have symptoms. The same is true for mental illnesses, depression, anxiety. You could suffer from those for the rest of your life, but it doesn't mean every day is bad. What matters is the specific day and the specific episode that you're under. You can't assume that every day of someone's life that they're suffering from symptoms of a disease.
Mr. Hitchcock, I appreciate your point, and particularly given the current times that we're in, evidenced by our courtroom itself, I dare say. However, I am inclined to allow it to come in and trust that your capable cross-examination will be able to differentiate it in the following manner that you just described. So with that, I think it's important that the jury hears it and ultimately makes the decision as a trier of fact. Okay?
Yes, Your Honor.
Great, let's move on. Thank you.
Permission to publish Exhibit 10 on the screen, Your Honor.
You may.
Detective, taking a look at Exhibit 10, what was the first search conducted by the defendant?
Countries that don't extradite for murder charges.
What was the second search?
Second search, I apologize, I can't see it totally. Thank you. How to get rid of a body.
Detective, what was the third search performed by the defendant the day after he killed his son?
Does bleach destroy a body?
Detective, I want to now bring you back to the night of the interview with the defendant. During that interview, did the defendant express any remorse?
Yes, absolutely. He said, I didn't mean for any of this to happen. I didn't mean to kill him.
Nothing further.
Thank you, Ms. Brill. Cross?
Yes, Your Honor. Detective, you think my client is a piece of shit who'd be better off dead, right?
Those are statements that I said, yes.
That's statements that you said at the end of your interrogation with him.
After he confessed to killing his son, yes, absolutely.
But this interrogation, it wasn't the first time that you met Mr. Ray, was it?
No, my son played soccer with his.
That's right. So you would see Mr. Ray at soccer practices or games.
Yes.
But even then, you didn't like him, did you?
I wouldn't say I didn't like him.
Well, you thought he was socially awkward.
Yes, that doesn't mean I didn't like him.
Hard to have a conversation with.
Yes.
Didn't fit in with the other parents.
Yes.
Now let's talk about the defendant's behavior during the interrogation. Now,
Sure.
According to you, it was a normal interview, right?
Yes, it was an average interview. I see lots of criminal defendants every day, so yes, very average.
I mean, nothing that Mr. Ray said was odd.
No.
Your Honor, permission to publish portions of Exhibit 3.
I don't know that we have 3 in yet, do we?
Your Honor, these are being used for impeachment purposes.
Okay, sure. You can show, well, you can publish it to the witness is what I think you mean to say, right?
Your Honor, we'd be using these as a demonstrative if we were in court today as specific portions of the testimony that directly impeach the witness. So we'd like to publish it to the court as a whole.
Okay, are you going to read it? What are you going to do with it?
We're going to read it and we're going to ask about how normal this is.
Okay, very well. Thank you. Thank you.
So let's talk about how normal the defendant's answers were. On page 41, lines 19 through 20, it says, question, what were you and Nathan doing? Answer, are you from the CIA? You're from the CIA, aren't you? Nothing odd here, right?
No.
Okay, well, how about this? On page 42, it says, question, what happened to your laptop? Answer, it was because she tricked him. They told me she tricked him. She tricked him to do it. I know it. She tricked him to spill the juice on it because she wanted to take him away from me. This made sense to you?
Look, criminal defendants say a lot of things when they're trying to get out of a criminal indictment. So no, this was not unusual.
Wait, stop. Is there an objection, Ms. Brill?
Yes, Your Honor. These statements are not being used for impeachment purposes. There is no inconsistent testimony from Detective Booth that goes against the testimony that they are presenting on the screen today. And therefore, these are not being used for demonstrative purposes only. And it runs the risk of the jury taking the truth of the matter of these statements.
Mr.
Your Honor, if I may, there's a pretty clear contradiction, and it's up for the jury to decide whether or not these types of statements, which the detective just said, are normal.
But Mr.
In addition,
Hitchcock, Hitchcock, that may be true, but it is up to the court as to what to decide as admitted evidence and what isn't. So,
but Your Honor, these hearsay statements are not being offered for the truth of the matter asserted. That's the entire point of these statements.
no, they're not. You offered them for impeachment purposes, and I'm curious, what testimony are you impeaching?
I'm impeaching the testimony of Detective Booth that she said nothing the defendant said was odd. It was a normal interview.
Ms. Brill?
Your Honor, that is not the testimony that they are putting on the screen right now. It does not go directly against the testimony. It's not like Detective Booth testified prior to this trial saying that this was in fact an odd and not normal interview. What she testified today that this was a normal interview, and her previous testimony does not cut against the testimony she gave today.
Last chance, Mr. Hitchcock. I think I want to give you one more shot there.
Your Honor, this is non-hearsay for two purposes. First, it goes towards impeachment. It is directly inconsistent with what the witness just said, that nothing the defendant said was odd. These statements, I believe most rational people would agree, are odd. The second thing that it's a non-hearsay purpose is that none of these are being offered for the truth of the matter asserted, or rather they're going to show Mr. Ray's state of mind, that these are odd. Both of these are entirely relevant to for the trier of fact to hear today and are non-hearsay purposes. I think
Based on Ms. Brill's objection, I'm gonna overrule the objection as it's written, as you worded it. This witness did testify exactly to that effect. The question was asked, the question was answered, and then proceeded upon what happened next was an impeachment based on that answer. If you had an objection with regard to the word odd, I didn't hear that today. So based on your objection, Ms. Brill, I'm going to overrule it based on how it was worded. And with that, Mr. Hitchcock, please continue.
Again, detective, on this page, it says, question, what happened to your laptop? Answer, it was because she tricked him. They told me she tricked him. She tricked him to do it. I know it. She tricked him to spill juice on it because she wanted to take him away from me. Nothing strange here either.
Again, criminal defendants will say a lot of things to get out of their indictment. So no, this is not odd. This is very usual behavior for a criminal defendant.
Well, detective, you don't know who this they are, is it? Do you?
No, I don't.
You never ask who he's referring to when he says they.
No, I didn't.
And in fact, this isn't even the only time that he mentions this ambiguous they, right?
No, it's not.
Because further on down the page, it says, question, how did that make you feel? Answer, I didn't mean to. You have to know how ashamed I am. You have to know how sorry I feel. I would have never done it if they hadn't told me to.
Objection, Your
They
Honor.
told me to.
Your Honor, this is non-impeaching. This is not impeaching Detective Booth's testimony given today or prior testimony.
Your Honor, if I may, these are both impeachments and they are serving as a non-hearsay purpose of evidence of Mr. Ray's mental state.
I think, counsel, you had me at odd. I don't know that you have me on this line. I think that this line, we're outside the presence of the jury, obviously. I think that, how did it make you feel? I didn't mean to. You have to know how ashamed I am. That behavior is not necessarily considered under the definition that you elicited prior to this particular slide, this demonstrative, which you were centrally focused on the word odd. This to me is outside that bound.
Your Honor, if I may, on their direct examination, they did bring up that Mr. Ray was remorseful. So this first part, we're more than happy to cut.
But sir, that was not your question. That was not your question to this witness. Your question to this witness again, and then she answered it again, was the behavior odd? And the witness said, no, it wasn't odd, which is up for impeachment, as you did thus far until you got to this particular demonstrative. This, if you can point me, counsel, to the specific language in this demonstrative that you are alleging is odd, then I will hear you. But other than that, I'm going to sustain the objection on this.
Your Honor, line 21 says, how did that make you feel? At the end of line 22 through the rest of the part of this demonstrative, it says, I would have never done it if they hadn't told me to. They told me to. They told me that she tricked him.
So I think I want you to, I think I want you to rephrase your question, because the question that and we'll strike the testimony up to that point, but I want you to rephrase your question to give this witness the chance to be impeached if that's your intention here. Because I don't disagree with you that the word they, and I understand what you're trying to do, but I think the way you're doing it is a little circuitous. And so I want to give you another chance to refine your question. Okay, and Ms. Brill, your objection is noted. Thank you. Mr. Hitchcock, please rephrase your question and we'll move from here, but we need to move on.
Your Honor, I'll just go ahead and move on. We could take the demonstrative down.
Very well, thank you.
Let's talk about what you did after seeing my client's behavior for yourself. All interrogations are recorded, right?
Yes, they are.
But we don't have that recording.
No, I made a transcript of it.
Well, there was an audio and visual recording, right?
Yes, which I didn't need because I made the transcript.
Detective, I wasn't asking whether you needed it. I was just confirming that one existed, and it did.
My answer was yes, I made a transcript.
But you decided not to preserve it.
I did preserve the transcript.
My question's about the audio recording. You decided not to preserve the audio recording, right?
I did not preserve the audio recording, no, sir.
Or the visual recording?
No, sir.
Even though you could have?
Yes, I can preserve all evidence if I'd like, yes.
You had 30 days after the interrogation to preserve this recording.
Yes, it wasn't needed. This was an open and shut case.
And to be clear, Detective, you made the decision not to preserve the recording after conducting the interrogation with my client, right?
Yes.
And this wasn't a confession for petty theft, was it?
No, it was a homicide.
That's right. This was a confession where the defendant confessed to strangling his son, mentioning voices in the CIA, and you decided not to preserve the recording.
Yes.
Detective, aside from you and Mr. Ray, nobody was in the room with you during the interrogation, right?
No.
As far as you know, nobody was watching while it was going on.
No.
As far as you know, nobody watched the recording before it was automatically deleted 30 days later.
I believe that's an inaccurate representation of my previous testimony. I stated that somebody did listen to the recording and transcribed what was on the recording. I assume that when audio and video are being played, they're being played together. That's how it's recorded.
You don't know who transcribed it, do you?
No, I do not specifically know the name of the transcriber.
Nobody told you that they transcribed it?
It was transcribed.
That wasn't my question. My question was whether somebody told you who transcribed it. And you don't
Nobody
know.
told me the name of the transcriber. No, sir.
Now, when you were conducting this interrogation, like you said, you made sure to get a transcript. And that records what was said during the interrogation, right?
Yes.
But the transcript, it doesn't record screaming, does it?
I'm not sure. I cannot answer that question.
Well, the transcript that you reviewed didn't have anything about screaming in it, did it?
There's no indication that Mr. Ray screamed during his interview. So no, it did not record any screaming.
So the transcript itself does not record screaming.
I cannot accurately say that. I don't know, sir.
Does it record crying?
I'm not sure.
Facial expressions?
No, it does not.
Where someone's looking?
No, it does not.
Whether it appears like they're talking to someone who isn't there?
No, it doesn't record that either.
So while the transcript records what was said, it doesn't record Mr. Ray's behavior.
No, that would be in the video.
And the only way we would know what the behavior was without this recording is from someone who saw it firsthand, right?
Yes, sir.
In this case, that's you.
Yes.
And detective, you've had 2 years to think about what your testimony would be today, right?
Objection. Argumentative.
Your Honor, this is cross.
Overruled.
You've had 2 years to think about what your testimony would be today, right?
Technically, yes.
2 years to think, knowing that my client is pleading a defense of insanity.
Yes.
And you think my client is a piece of shit who'd be better off dead.
Objection asked and answered.
Withdrawn, no further questions.
Sustained. Thank you, Mr. Hitchcock. Any redirect?
Yes, Your Honor. Detective, on cross-examination, you were asked about why you didn't preserve the video and audio recording. Why exactly did you not preserve it?
Because like I said, I preserved a transcript of it. And additionally, I don't need the audio or video because, again, this was an open shut case. He confessed to killing, in fact, strangling his 6-year-old son.
Detective, you were also asked about the defendant's demeanor during that interview. At any point during the interview, did the defendant say he didn't understand what you were asking?
No, he never said. In fact, he said he understood everything that I was saying.
Did the defendant ever speak incoherently?
No.
Did it ever look like the defendant was talking to someone else in the room that wasn't you?
No, it did not.
Objection, Your Honor. This is a series of leading questions.
Your Honor, this is redirect. I just need a little leeway.
Let's just be careful with your leading questions. I'll permit it, but let's move it. Let's move along, okay? Thanks.
Nothing further, Your Honor.
Great. May the witness be excused?
Yes, Your Honor.
Great. Detective Booth, you may step down. It's not subject to recall. Does the prosecution have another witness to call?
Yes, Your Honor. The state calls Dr. Mac LaGreca.
Dr. LaGreca, you're constructively sworn, and Ms. Wilkinson, you may begin your examination when you're ready.
Good afternoon. Please introduce yourself to the members of the jury.
Hi, my name is Dr. Mackenzie LaGreca.
What do you do for a living?
I'm a licensed psychiatrist.
How long have you been a psychiatrist?
For 26 years now.
Do you have any areas of specialization within the field of psychiatry?
Yes, forensic psychiatry.
Doctor, how did you become involved in this particular case?
I was asked by the state of West Carolina to review the materials in this case and provide my opinion as to whether the defendant was exhibiting signs of schizophrenia when he killed his son on October 17, 2018.
Were you able to form any opinions regarding the defendant's mental health?
Yes, I formed 2 opinions.
How much time did you spend reviewing the materials and forming those opinions?
25 hours.
Were you paid for your services, doctor?
Yes, I was paid $500 an hour to review materials and $17.50 flat fee to testify at trial.
Now, before we get to those opinions, I'd like the members of the jury to get to know you a little bit more. Where did you go to medical school?
I went to medical school at the University of Pennsylvania, the Perelman School of Medicine, and then I completed a residency at UCLA in general psychiatry, followed by a fellowship, specifically in forensic psychiatry.
After your education, did you join the workforce?
Yes, I had a practice in New Jersey for 23 years where I worked with patients, including those suffering from schizophrenia.
Are you board certified, doctor?
Yes, I am, in three states, as well as the American Board of Psychiatry and Neurology, where I am certified in forensic psychiatry.
What does it mean to be board certified?
Board certification means that you're trained in a specific area of medicine. You've taken an oral and written exam given by your peers in that specific area of medicine to demonstrate your mastery in that field.
Doctor, earlier you stated that you reviewed some materials regarding this case. What materials did you review?
I reviewed all the materials provided to me by the state, including the defendant's medical history and all exhibits in this case, the statements of all the witnesses, and the diagnostic and statistical manual.
Are these the types of materials that are typically relied upon by experts in your field?
Yes, they are.
And did you rely upon these materials in forming your opinions and conclusions?
Yes, I did.
Do you hold these opinions to a reasonable degree of medical certainty?
Yes, I do.
Doctor, if at any time you're unable to give your opinion to a reasonable degree of medical certainty, will you let us know?
Of course.
Your Honor, at this time, pursuant to Federal Rule of Evidence 702, we offer Dr. Mac LaGreca as an expert in the field of psychiatry with a specialty in forensic psychiatry.
Specialty in forensic psychiatry.
Yes, Your Honor.
Mr. Birch?
Your Honor, we have no objection as to the doctor's qualifications. If it comes up as to some conclusions, we might have an objection there.
Very well. With that, the court will admit Dr. LaGreca as an expert in forensic psychiatry. Ms. Wilkinson, you may continue.
Yes, Your Honor. Doctor, I'd like to turn to the work that you did in this case. Earlier, you mentioned that you formed some opinions. What's your first opinion?
Objection, Your Honor, improper opinion under 702. May be heard.
What's the basis of your objection, Mr. Birch?
Yes, Your Honor. Prongs B and C of 702. So as for B, expert can only testify an informative opinion if they rely on sufficient facts or data. In this case, the expert did not. The expert did not interview Mr. Ray, did not ever see Mr. Ray's behavior in a video footage or otherwise, and did not talk to anyone who knew Mr. Ray. Instead, this expert simply read some documents. And then as to prong C, an expert can only testify informative opinion if they use reliable principles and methods. Here, the doctor just said she reviewed the documents and that her methods were reliable, but she didn't articulate the methods. In this case, it's the court's duty as gatekeeper to determine whether these methods were actually reliable.
Mr. Birch,
None were articulated.
Mr. Birch, if your objection is based on 702B and C, then I read it as that the testimony is based on sufficient facts or data, which does not exclude or perhaps is exclusive only to a personal physician and patient interaction. And certainly you would agree that the record itself would suffice as sufficient facts or data under the rule. And by the way, on C, that the product of reliable principles and methods, I think the doctor testified already that she has used within a medical degree of certainty, and that her testimony was based on such practice. So I'm very close to overruling you here. So I'm going to give you one more chance to tell me why I shouldn't.
Yes, of course. We'll take it in reverse order. So as to B, although the doctor did say she relied on reliable principles and methods, she didn't articulate the actual method she used. She said she reviewed documents, and then the next question, like, did you use reliable principles and methods? No method actually was described in this case. And it's the court's role as gatekeeper to determine whether the method used in this case is actual reliable method. So
Okay.
we just ask that a method be explained.
Sure, fair enough. Ms. Wilkinson, why don't you ask a question? I'll reserve on your objection. Go ahead, Ms. Wilkinson.
Your Honor, we were just going to briefly mention the opinions and then get to those methods. Would you first like us?
Let's go into methods first, and then we'll turn around. We'll establish that, and then we'll move forward.
Okay. Dr. LaGreca, specifically, what methods or reliable sources of authority did you use in coming up with, or not coming up, in informing your opinions today, doctor?
I used the patient's past medical history records that were recorded by Major Riley. I used the documents from the interviews that he conducted with his father, his boss, and his ex-wife. And I looked at those. I used the DSM-5 for the criteria for schizophrenia and the factors that go into malingering. I looked at the evidence that was provided to me by the team, and I was able to form my opinion to my medical certainty based on those. And I also had the case file joint exhibit list.
Thank you, doctor. I'd now like to turn back to those opinions.
So before we do that, counsel, thank you. Before we do that, I heard her say that she relied upon the medical records and, well, the records, which is inclusive medical records, and also the other various documentation and interviews. Does that satisfy your objection, Mr. Burrich?
That's a prong C. She stated that she used the DSM-5, which is accepted as a diagnostic tool. But however,
sorry, I just would like to remind opposing counsel that we did stipulate that the DSM-5 is a reliable source of authority for malingering and schizophrenia.
He's saying that. That's what he said.
I agree wholeheartedly.
Yeah.
However, I don't believe the B prong has been established, and therefore my 702 objection stands.
Understand. I'm going to overrule your objection. Your objection is noted, sir. Thank you very much for your information there. Ms. Wilkinson, you may continue your examination.
Yes, Your Honor. Doctor, earlier you mentioned that you formed some opinions. What is your first opinion?
That on October 17, 2018, the day that the defendant killed Nathan Ray, the defendant did not manifest symptoms sufficiently consistent with a person suffering from schizophrenia.
What is your second opinion?
That the defendant actually manifested signs consistent with malingering during his clinical interview with Major Riley on September 8, 2019.
Doctor, I'd like to start with that second opinion and then work backwards. You mentioned malingering. What is malingering?
Malingering in any case is pretending to have symptoms of any disorder. So in this case, we're looking at a mental disorder. It can be seen as a form of manipulation, as an ulterior motive. Although it is often seen in legal cases, it can be used in any situation that the person can benefit from doing so.
Doctor, is it your opinion that the defendant was pretending to have symptoms of a mental disorder?
Yes, actually, both during his interaction with the officers and with Major Riley.
What mental disorder was the defendant pretending to have?
Schizophrenia.
And doctor, how can you determine if someone is malingering?
Although malingering is not a specific diagnosis, there are very specific factors listed in the Diagnostic and Statistical Manual, also known as the DSM-5, which we've mentioned before.
Doctor, do you have any materials that would help you explain these factors of malingering to the members of the jury?
Yes, I actually have a Prezi presentation.
For the record, directing everyone's attention to what's previously been marked as Exhibit 31 for demonstrative purposes. Dr. LaGreca, do you recognize Exhibit 31?
Yes, I do.
What is this?
This is an informative Prezi presentation breaking down malingering and its factors.
Did you participate in the creation of this Prezi?
Yes, I did.
Would this demonstrative help you explain your testimony to the members of the jury?
Yes, it will.
Your Honor, permission to enter Exhibit 31 into evidence for demonstrative purposes only?
Any objection?
Just to characterizing it as Exhibit 31, this wasn't a part of the preset 30 exhibits in this case. However, just for demonstrative purposes, that's fine.
I'm inclined to agree. I think we'll call it Prosecution 1, or Prosecution A. How's that? And if no objection to the demonstrative, then Ms. Wilkes, you may continue.
Your Honor, permission now to publish Prosecution 1A on the Zoom screen. Sorry.
All right, no, I confused you. That was my fault. We'll call it Prosecution A. I apologize. Prosecution A is what the demonstrative would be, and you may publish it.
Dr. LaGreca, taking a look at Exhibit A, can you walk us through those factors of malingering you just mentioned?
Yes. So first, I considered the legal context of a clinical assessment, which is whether or not the patient is being prosecuted for a crime. The second factor is if there are discrepancies between the person's claim disorder and the objective findings by a physician.
And what type of discrepancies do you typically find when a person is malingering?
I'm looking for differences between what the person is claiming versus the objective findings of the doctor and those around him. So in this case, Major Riley interviewed the supervisor, his ex-wife, and his father. There was never any mention of him having any hallucinations.
Are there any other factors that you consider?
Yes, there are actually two additional factors. So the third factor is the failure to cooperate during a diagnostic evaluation. And the fourth factor is whether there's a presence of an antisocial personality disorder.
Doctor, how many of these factors are required to determine if someone is malingering?
As malingering is not a diagnosis, there aren't a set number of factors. So really any combination of these factors can hint at it, yes.
Doctor, you mentioned that there were multiple times when the defendant was pretending to have symptoms of schizophrenia. Let's talk about those times. When was the first instance in which the defendant was malingering?
The first incident was the night that he was stopped by Officer Wentz at the checkpoint. The defendant changed his behavior when facing legal consequences, in this case, the possibility of arrest. For example, when Officer Wentz asked for his license, the defendant started asking about the CIA. Then once the officer saw the shovel and the other items in the car, the defendant began moving slowly, or as we call it, becoming catatonic. Lastly, he made a drastic change of behavior when being interviewed by Detective Booth. He was calm in the car ride to the station, but then started crying upon seeing the homicide detective.
What does all that indicate to you?
It indicates to me that he changed his behavior when he was facing legal consequences to a set of very specific symptoms. I'm not surprised by this because he's had many interactions with mental health providers and would likely have a good idea of what symptoms to portray.
Doctor, when was the next time that the defendant appeared to be faking symptoms?
The next time was after the defendant was arrested for the first-degree murder and was interviewed by Major Riley. During his interview, the defendant admitted to hearing voices and not having any intrusive or anxious thoughts in the months leading up to the incident. This is a very strong sign of malingering because the average person would not be able to distinguish between these two very specific symptoms of schizophrenia and anxiety disorder.
Doctor, taking a look at all of these factors that we just went over, did the defendant demonstrate any of these?
Yes. So first, without a question, it's clear that the defendant was in the process of being prosecuted for a crime. Second, he gave inconsistent accounts of what happened on the day of the incident, like where it happened, which also indicates that he was malingering. Lastly, he was not cooperative with Major Riley during his interview.
Doctor, did you come to learn what happened in the moments before the defendant killed his son?
Yes.
How did you learn?
I reviewed what the defendant told Major Riley.
Right before the defendant killed his son, what did he do?
He sat on his bed and tried to calm himself down, but then ended up getting a belt from his dresser, walking into Nathan's room and strangling his son.
Doctor, was the defendant suffering from schizophrenia on October 17th, 2018?
No, he was not.
No further questions, Your Honor.
Thank you, Counsel Cross.
Yes, Your Honor. May I proceed? Hello, Dr. LaGreca.
Hello.
I'd like to start by talking about whether you had enough information to form your conclusions. Now, you concluded that Mr. Ray is malingering. That's true?
That is correct.
So, in other words, you concluded that Mr. Ray is faking the symptoms of schizophrenia.
Yes.
Before his son's death, Mr. Ray attended 4 sessions with medical professionals that you're aware of.
Yes.
You weren't at any of them, right?
No.
After his son's death, Mr. Ray talked to multiple police officers.
Yes.
You weren't at the traffic stop with Officer Wentz.
No.
You weren't in the interrogation room with Detective Booth.
That would be inappropriate, I would think. No, I was not.
So just to be clear, you weren't there.
No.
Instead, you read about these interactions.
Yes, I did.
But Dr. LaGreca, you'd agree with me, there's a difference between a written transcript and being in the same room.
Of course, they offer different things.
Right. A written transcript, it doesn't show a person's body language.
Not usually, no.
The written transcript you reviewed didn't show the body language.
No, it did not.
A written transcript doesn't show a person's facial expressions.
No.
A written transcript doesn't show tone of voice.
I'm sorry, could you repeat that? I didn't hear you.
No worries. A written transcript doesn't show a person's tone of voice.
No.
Now, you concluded that Mr. Ray is malingering without ever treating Mr. Ray.
I looked at a lot of different things to come to that conclusion. And yes, I did come to the conclusion that he was malingering.
But just to be clear, you didn't treat Mr. Ray, right?
No, I did not treat Mr. Ray.
You didn't ever see Mr. Ray.
I would have been very happy to see Mr. Ray and talk to him in person, but I was told that you guys would not let me interview him.
So, Dr. LaGreca, to be clear, you never saw Mr. Ray before or after his son's death?
No, I did not.
You never spoke to anyone who knew Mr. Ray?
No.
You were never in the same room?
No.
Now, this would be the 8th time you've been retained to in a criminal case, right?
Yes.
But it hasn't been a 4-4 split between prosecution and defense.
No.
6 out of 7 previous times you've been retained by the prosecution.
Yes.
After today, that's 7 out of 8.
That is correct.
I want to talk a bit more about your conclusions. You believe Mr. Ray was not suffering from schizophrenia.
That is correct.
But doctor, it's true. A person's more likely to have schizophrenia if they're showing several signs and exacerbating factors.
I don't know if that's the case here, but that can definitely be the case, yes.
Doctor, I'm not talking about this specific case. I'm just talking generally. If a person is showing several signs associated with schizophrenia, has several exacerbating factors, that person's more likely to have schizophrenia when compared to someone who's showing none of them.
That is correct.
Let's talk about some of those signs and exacerbating factors. Your Honor, permission to present a demonstrative?
Objection, Your Honor. We would like to object before the defense publishes this on the screen.
What's the basis of your objection?
We were able to see this demonstrative, and we object to it being substantially more prejudicial than it is probative. The way it's set up, Your Honor, it lists symptoms of schizophrenia that we have a good faith basis to expect the defense will start to list as the cross goes on. Your Honor, this setup, the way they have it, risks confusing the jury as to.
Okay, hold on a second. We're outside the presence of the jury. Let me see what we're talking about so that I can understand what your argument is, counsel.
Yes, Your Honor.
So, Ms. Wilkinson, go ahead. Tell me what your objection is.
Were you able to see the demonstrative the way it's set up, Your Honor?
Yes, thank you. I can see it.
The way it's set up, it's just unclear as to whether the defense is saying that our expert is testifying as to the fact that because the defendant was exhibiting these symptoms, that they were indicative of schizophrenia.
Okay, Mr. Barrett.
Yes, Your Honor. Each of these symptoms listed has a page and line number in Dr. LaGreca's report or is referred specifically in the DSM-5. They won't be presented to the jury until the doctor agrees each symptom is either a sign or exacerbating factor of schizophrenia. We're not right now directly tying any of these symptoms to the defendant. I mean, we're cross-examining a state's doctor, but we are establishing that these are symptoms, and yeah, that's it.
Your Honor, may I say one more thing? Sorry.
Sure.
Your Honor, it's our position that this will confuse the jury because we believe that seeing these factors on the screen will give the impression that the defendant exhibited these symptoms, and that's why we're objecting.
Okay.
Maybe heard, Your Honor.
I don't think so. I think I'll tell you this. Generally, I think this seems like all of these factors and quotes exacerbating factors and schizophrenia signs. I'm not sure where that language comes from, Mr. Barrett. On the other hand, the prior anxiety disorder, childhood trauma, family history, severe mental delusions, hallucinations, those are all, as you said, I think they're included in the record. Is that right, Ms. Wilkinson? Are those items included in the record?
Your Honor, they're included in the record as exacerbating factors. However, in Dr. LaGreca's report, she specifically testified that the defendant didn't exhibit any of these factors.
Okay,
So
let's do this. Let's say that this demonstrative will be permitted as a summary, and then at the same time, we'll let you have the opportunity to redirect on that if that's what you like. Okay.
Thank you.
All right. Thank you.
May I continue? Oh,
Mr. Barrett, you can go ahead and use your demonstrative at this time, and at the same time, I would encourage counsel to make it available for opposing counsel should she request it for redirect. I'm sure you wouldn't have any objection to that, would you, Mr. Barrett?
no objection whatsoever. We have opposing counsel's email. If they request it, we'll send it their way.
Thank you. All right, that's nice.
May I continue, Your Honor?
Yeah.
So let's talk about some of those signs, Dr. LaGreca. It's true that a anxiety disorder can worsen and lead a person to develop a more serious mental illness, right?
In some cases, definitely not all. Yes.
So it's possible, in your own words, for anxiety disorder to worsen and lead to a more serious mental illness.
Yes.
Like schizophrenia.
That can definitely be one of them.
Mr. Ray was diagnosed with anxiety disorder before October 2018.
Yes, he was.
Now, it's also true that childhood trauma makes a person more likely to develop a severe mental illness like schizophrenia.
Unfortunately, there's a wide population of people that go through childhood trauma, and many of those people don't develop schizophrenia. But to answer your question, yes, childhood trauma can increase the chances of someone getting schizophrenia, but it's not the most common thing.
So that's a yes to my question. It does make a person more likely to develop a severe mental illness compared to someone who doesn't have childhood trauma in their life.
Yes, it can.
And Mr. Ray, he suffered from childhood trauma.
That is what his father reported.
Right, and that's what you reviewed in this case.
I reported the father's interview.
You reviewed the father's interview, right?
Yes.
About how Mr. Ray took cold baths, very ice cold baths with his mother.
Yes, that's what he stated.
Wasn't fed at times from his mother.
That is also what he stated.
Was neglected by his mother.
That is what his father said.
Now, a family history of severe mental illness, that also makes a person more likely to develop a severe mental illness like schizophrenia.
Yes.
Mr. Ray's mother suffered from a severe mental illness.
She was never diagnosed with one.
Well, you'd agree that she was institutionalized when Mr. Ray was just a child.
There are many reasons why someone can be institutionalized. A mental disorder is not always one of them.
Well, she went through constant mood swings that were severe, right?
That is what was stated by his father.
She bathed her child in ice cold water, right?
Yes.
She wouldn't feed her child at times.
That is what he said, yes.
She neglected her child.
That is what he said.
Now, I want to talk about the DSM-5. You'd agree that's a reliable authority on schizophrenia diagnosis.
Of course.
Now, the DSM-5, it states that delusions are a sign of schizophrenia.
Yes.
You'd agree that, sorry, I'm a bit distracted by the chat. You'd agree that in 2016 or 2017, Mr. Ray visited Dr. DiGiuseppe.
Yes.
And during this visit, Mr. Ray told the doctor he feared his wife was having an affair.
Yes, he did.
He then accused the doctor of taking his wife's side.
Yes, after she asked if he was going to hurt his wife or son.
Right, so that's a yes to my question. He accused the doctor of taking his wife's side, not his.
Yes.
He accused the doctor of talking to his wife behind his back.
Yes.
He accused the doctor of listening in on his phone calls.
That is what the record said.
To be clear, this visit happened before October 2018, right?
Yes.
Now, the DSM-5, it also states hallucinations. That's a sign of schizophrenia.
Yes.
Mr. Ray said he started hearing voices when he was a child.
After he was arrested, yes.
So that's a yes. He said he started hearing voices when he was a child.
He did. It is unclear what those voices were, but yes, he did.
He said he started hearing them again in 2015.
Yes, after he was arrested, he stated this. Yes.
So that's a yes to my question. He said he started hearing them again in 2015.
Yes, that's what I said.
And then in 2018, he said they came back.
Again, after his arrest. Yes, that is what he stated.
Again, Dr. LaGreca, I'm not asking about the timeline, about when he said it. I'm just asking if he said it. And he did.
Yes.
Now, during Mr. Ray's interrogation, it's true that he said multiple times, they told me she tricked him, right?
Yes, that is what the record shows.
But Dr. LaGreca, you never saw the footage of this interrogation.
No, it was not available.
Thank you. Nothing further, Your Honor.
Thank you. Ms. Wilkinson, redirect?
Yes, Your Honor. We would like to republish that really quick.
Sure. Thank you. Thank you, Mr. Burrich. Appreciate that.
Dr. LaGreca, you were asked about the signs and factors of schizophrenia on cross.
Yes.
Doctor, was the defendant diagnosed with anxiety disorder, not schizophrenia, in 2010 by Major Riley?
That is correct.
And the defendant had experienced childhood trauma prior to the 2010 evaluation by the defendant's expert.
Yes.
And in terms of family history, doctor, was either of the defendant's parents diagnosed with a mental illness?
They were never diagnosed.
And doctor, in terms of delusions and hallucinations, did the defendant ever exhibit these symptoms?
Not prior to his arrest.
No further questions, Your Honor.
Thank you, Ms. Wilkinson. Are there any other witnesses for the prosecution to call at this time?
No, Your Honor, the state rests.
If the state rests, then let's have any mid-trial motions.
Yes, Your Honor. Because we're pleading an affirmative defense in this case, we're not bringing a motion to dismiss under Rule 29 today.
Okay. And with that, how about a time check from our timekeepers?
Your Honor, we just need to confer quickly with opposing counsel's timekeeper, and then we'll get back to you. Would you mind if we got back to you after the break?
Sure, that's great. Let's take, well, I hope there's time for the break. Let's do, what do you guys want? How much time do you need?
5 minutes is fine with us, Your Honor.
5 minutes. Let's do that. My clock says 5:57. We'll be back literally at 6:02. Okay, thank you very much.
Thank you.
Okay, do we have everybody back? Oh, no.
Your Honor. Well, I'm not sure if we have everybody back, but did you want to know the times right now? Or would you-
Let's wait, make sure council's back to hear that, please.
Sure.
Thank you so much. Yeah, we'll give them another 30 seconds. Council, are you ready to hear time checks? Do we have?
Yeah, we're fine.
Okay, all right. So if the timekeepers want to give time checks, that'd be great, please.
Okay, great. So for the state, there's 23 minutes and 20 seconds left. And for the defense, we have 31 minutes and 23 seconds left.
Thank you very much. I assume, since there is an affirmative defense that has been brought forth in this case, I assume that the defense will be putting on a case in chief. Do I have that right?
Yes, Your Honor, we will.
My incredible powers of deduction have not failed me yet. Thank you very much. And with that, if the defense is ready to proceed, you may call your first witness.
Yes, the defense calls Dr. Riley to the stand.
Dr. Riley, you're constructively sworn. Good evening. And Mr. Hitchcock, you may begin your examination.
Good afternoon. Please introduce yourself to the jury.
I'm Dr. or Major Shane J. Riley.
What do you do for a living?
I'm a forensic psychiatrist.
How are you involved in today's case?
I was asked to determine whether Timothy Ray was suffering from schizophrenia or another mental illness on October 17th, 2018.
Now, before we get to your conclusions, I want the jury to get a sense of your qualifications. Where'd you go to school?
I attended the Uniform Services University School of Medicine, and following that, I did my general psychiatry residency, followed by a forensic psychiatry fellowship at Walter Reed National Military Medical Center.
How long have you been practicing?
Since 2002.
Are you published in your field?
Yes, I have 15 publications.
Do any of those publications specifically relate to schizophrenia?
2 of them do.
Apart from your work in today's case, do you have any experience determining if someone has schizophrenia?
Yes, certainly. That's part of standard general psychiatry training, and I did that plenty of times in my practice.
Finally, just to be complete, are you being compensated for your time?
Yes, I am.
The defense offers Dr. Riley as an expert in forensic psychiatry and schizophrenia.
Ms. Brill?
No objection, Your Honor.
Without objection, the doctor will be admitted as an expert in general psychiatry, did I hear you say? Or forensic psychiatry?
Forensic psychiatry and schizophrenia, Your Honor.
Thank you very much. Forensic psychiatry and schizophrenia. Thank you. You may continue.
Now let's talk about your work in today's case. Was Timothy Ray a patient of yours?
He was once in 2010 at Walter Reed.
Well, when did you conduct interviews with Mr. Ray?
I conducted clinical interviews both in 2010 and then again in 2019.
Apart from these interviews, what materials did you rely on in your work for this case?
I relied on the evidence in the joint exhibits, as well as interviews with 3 other people: Mr. Ray's father, his ex-wife, and his former boss.
Now, were these materials sufficient for you to form any conclusions to a reasonable degree of medical certainty?
Yes, when compared to the DSM-5, they were.
What exactly did you do with these materials? What methods did you use?
So I compared all of the information that was available to me with the diagnostic criteria in the DSM-5.
Is comparing
for
this... My apologies. Go ahead.
Specifically for schizophrenia and malingering.
Would you say that comparing someone's symptoms that are exhibited to those listed in the DSM is a standard method in psychiatry?
Yes, absolutely.
Did you reliably apply that method to the facts and data of this case?
I did.
All right, doctor, if you could tell the jury, what were your conclusions?
My conclusions were that Timothy Ray suffers from schizophrenia and that he was indeed suffering from schizophrenia on October 17th, 2018.
Let's break those down for the jury, starting with your first conclusion. First, could you tell the jury what schizophrenia is?
Schizophrenia is a psychiatric disorder classified as a psychotic disorder that involves both positive and negative symptoms.
Is every case of schizophrenia the same?
No, certainly not. Schizophrenia has a broad range of presentations from mild to very severe.
So do people suffering from schizophrenia always know the difference between right and wrong?
Objection, Your Honor. This is going to the ultimate issue, which was barred in motions in limine.
Your Honor, may I be heard?
I'm going to sustain the objection and ask you to rephrase.
Your Honor, if I may, this question wasn't specifically about the defendant's ultimate issue, his subjective state of mind. Instead, it's whether or not people suffering from schizophrenia always know the difference between right and wrong. And that isn't the ultimate issue. That's barred under Rule 704.
That unfortunately, we do not have the benefit of a court reporter, but I'm pretty sure I heard the question and the answer. So I'm gonna sustain the objection, note your objection, and let's move on. Okay.
Yes, Your Honor. A minute ago, you said you used the DSM to diagnose Mr. Ray with schizophrenia. How'd you do that?
Well, I looked, there are a total of 5 signs of schizophrenia in the DSM. 2 of them must be present, at least 2 of them must be present for at least a month in order to make a diagnosis of schizophrenia. And that's how I made this diagnosis.
How many symptoms did you determine Mr. Ray was exhibiting?
I determined he was exhibiting 3: hallucinations, delusions, and negative symptoms.
All right, let's break those down for the jury. I understand that you've prepared a chart to assist with your testimony today, correct?
That's correct.
Your Honor, permission to display Dr. Riley's chart.
Any objection from opposing counsel?
Not at this moment, Your Honor.
And therefore, yeah, you may proceed. Thank you, Mr. Hutchison.
The first symptom that we have listed here are hallucinations. Could you tell the jury what hallucinations are?
Hallucinations are perceptions not substantiated by reality. Seeing things, hearing things, feeling bugs crawling under your skin.
Why did you conclude that Mr. Ray was suffering from hallucinations?
Well, he reported hearing voices and also seeing shapes.
How long had Mr. Ray reported experiencing hallucinations?
The auditory or heard ones dated as far back as 10 years old, and the visual ones may have dated as far back as 2010.
Let's turn to the second symptom you have listed here, delusions. What are delusions?
Delusions are fixed false beliefs.
Why'd you determine that Mr. Ray was experiencing delusions?
Well, because he had a lot of paranoia regarding his wife and son, and made many accusations about people, the officers in particular, being CIA, and they were following him for being a terrorist.
How long had Mr. Ray been experiencing these delusions?
At least as far back as 2015.
The last symptom on your chart is something called negative symptoms. What are those?
They're sort of the absence of normal things or things that interfere with normal functioning, such as not maintaining grooming, difficulty interacting socially, and so forth.
Why did you conclude that Mr. Ray was experiencing negative symptoms?
Well, there are a couple of reports that he was generally poorly kept, had some changes in his sleep patterns, and difficulty interacting with other people.
How long had he been experiencing these negative symptoms?
Since at least 2017, worsened in late 2017, 2018.
All right, doctor. I want to focus specifically on October 17th, 2018. Were you able to determine if Mr. Ray was experiencing a schizophrenic episode that day?
Yes, I was. And I believe he was.
What's your opinion on that?
My opinion is that he was exhibiting a schizophrenic episode on October 17th, 2018.
How do you know?
Well, because he once again exhibited 3 signs of schizophrenia.
Let's go one at a time again. What hallucinations was he experiencing that day?
He was experiencing voices telling him that his wife had tricked his son, instructing him that he had to kill Nathan.
And what about delusions?
Yes, he had the delusion that the officers were CIA, the delusion that his son was possessed with evil.
And negative symptoms?
He similarly been poorly kept, was really not regulating his emotions appropriately.
All right, doctor. I'm no expert here, but couldn't Mr. Ray have just been making all these up?
He could have been, but it is my firm belief that he was not.
Well, how confident are you, based off of your hard work in today's case, that Mr. Ray is not malingering?
I am very confident. Based on my interviews with him, I have determined to a reasonable degree of medical certainty that he was not malingering.
Thank you, doctor. Your Honor, we have no further questions at this time.
Great. You can take the demonstrative down then, please. Thank you.
Your Honor, actually, can we leave the demonstrative up just briefly
Oh,
for my cross-examination?
Sure.
Thank you, Your Honor.
You may begin.
Thank you. Major, taking a look at this demonstrative we went over on direct examination, hallucinations, delusions, those 2 symptoms weren't reported by the defendant until after he was arrested, correct? Thank you. I'm done with the demonstrative. Now, Major, you typically charge $450 an hour to review materials.
Yes, typically.
But today, you cut a deal with the defendant.
Objection on the phrasing, Your Honor. This implies that Dr. Riley is somehow nefarious, cutting a deal. We'll stipulate that Dr. Riley gave a discount, but cutting a deal implies the testimony itself was impacted. You're on mute, Your Honor.
Okay, let's keep it moving. I appreciate the point, but let's keep it moving and above board. Thank you, Ms. Bro. Please go ahead.
Major, you're charging the defendant a cheaper rate for your testimony, right?
Yes, that's correct.
And that's because you and the defendant have a history.
A history of being in the armed services, yes.
And you want to ensure a favorable outcome, correct?
That is my hope for all people suffering from mental disease.
Major, you concluded that the defendant was exhibiting symptoms of schizophrenia on October 17, 2018, right?
Yes, I did.
And one symptom you claimed that he exhibited were auditory hallucinations.
Yes, I claimed that on the basis of the defendant's testimony.
Well, Major, just to be clear, just like the hallucinations and delusions the defendant reported, hearing voices weren't reported by the defendant until after he was arrested, correct?
Correct.
In fact, the defendant didn't report hearing voices until after he was questioned by Detective Booth.
Correct.
Now, you also relied, on an interview given by the defendant's employer, Nia Jacobs.
Yes, I did.
And Ms. Jacobs told you that the defendant was a fantastic employee for 8 years.
I believe it was 7, but that was what she reported.
Sure, Major Riley. So the defendant was a fantastic employee for 7 years.
Yes.
And you would agree, Major, that it's atypical for a schizophrenic person to maintain steady employment for 8 years.
Atypical, but not unheard of.
Well, Major, you didn't say that the defendant's case was rare, did you?
Not that I recall.
Now, you also stated that family history of mental illness can increase someone's likelihood for having a mental illness.
Yes, it can.
Do you believe that's the case with the defendant?
Yes, I do.
But you would agree, Major, that the defendant's father was never diagnosed with a mental illness.
No.
The defendant's mother was never diagnosed with a mental illness.
Not that we're aware of, although there is the report that she was institutionalized, which presumably would have involved a diagnosis being made.
Well, Major, you didn't interview the defendant's mother, did you?
No, she died in 2002, so that would have been impossible.
Well, you didn't even seek her medical records, right?
No, I did not.
Now, you also diagnosed the defendant with anxiety disorder and depression in 2010.
Yes, at that time, that was my diagnosis.
Right, you didn't diagnose him with schizophrenia.
No, not at that time.
In fact, at that time, the defendant denied experiencing hallucinations.
Yes, that's something that many people do to avoid stigmatization.
Major, he even denied having delusions, isn't that right?
Yes, in 2010.
Now, today you told this jury that the defendant was not malingering on September 8, 2019.
Correct.
Truth is, Major, you can't say with certainty whether or not the defendant was faking symptoms of schizophrenia.
Medicine is not an inherently certain business, and I said to a reasonable degree of medical certainty that he was not faking symptoms.
Major, those are your words. You can't say with certainty that the defendant was not malingering, correct?
Correct.
Now, the auditory hallucinations the defendant did claim to hear, he described those hallucinations with pretty specific medical terms, right?
Yes.
Right, Major, he told you he was experiencing auditory hallucinations and not intrusive thoughts.
Yes.
And the defendant also told you what happened on October 17, 2018.
Yes, he did.
But his story was off on several key facts, correct?
Yes.
First, he told you Nathan picked up and smashed his laptop. Is that a yes? Then, the defendant told you that wasn't true.
Correct.
Next, the defendant told Detective Booth he strangled Nathan in Nathan's bedroom.
Correct.
But to you, he again said something different.
That's correct.
He told you he strangled Nathan in the kitchen.
Yes.
And just to be clear, Major, you would agree that a lack of consistency in a person's story is a sign of malingering, correct?
That's one potential explanation of it, yes.
And when you confronted the defendant with these inconsistencies, he shut down.
Yes, you could call it shut down or was a little bit emotional, certainly.
Well, Major, in your words, he became angry when you confronted him with his story.
Yes.
You would agree that a lack of cooperation during a diagnostic evaluation is a sign of malingering, correct?
It is something that would make one think about that, certainly. Although I determined to a reasonable degree of medical certainty that that was not what he was doing.
Major, is that a yes? It's a sign of malingering?
Yes, it is.
Nothing further.
Any redirect, counsel?
Yes, Your Honor. Dr. Riley, on cross-examination, you were asked about when Mr. Ray reported his symptoms. Is when someone reported their symptoms the same as when they were experiencing them?
No.
Did Mr. Ray say why he didn't report his symptoms?
He said that he was afraid of being labeled.
Thank you. Your Honor, we have no further questions.
Thank you. May the witness be excused?
We believe so, yes.
Okay, great. Doctor, thank you very much for your time and your presence today in the court. Does the defense have any other witnesses to call?
Yes, Your Honor. The defense calls Officer Payne Wentz to the stand.
Officer Wentz, you are constructively sworn, and Mr. Pirich, you may begin your examination.
Hello, Mr. Wentz. Can you please introduce your... Hi. Can you please introduce yourself to the members of the jury?
Sure. My name is Officer Peyton Wentz.
What do you do for a living?
Well, I'm a police officer right here in Skelton County.
What training did you receive to become a police officer?
I went through the typical police academy training that everybody goes through. I learned about the laws of West Carolina, criminal investigations, and patrol procedures. I also participated in the crisis intervention team. It's basically a special training program for mental health issues.
I want to talk about how you're involved in today's case. Do you know Timothy Ray?
Yes, I do.
How so?
Well, I was the one who stopped Mr. Ray at our DUI checkpoint, just off of Route 22 on October 18th. This was the stop that ultimately led to his arrest.
Well, let's take a step back. Officer Wentz, what were you doing right before you stopped Mr. Ray?
Well, before we stopped Mr. Ray, it was just a routine traffic stop. My partner and I were sending people through the checkpoint just like usual. We hadn't even made any arrests up till that point.
When did you stop Mr. Ray?
That would have been around 9 p.m.
And how's Mr. Ray looking when you first stopped him?
His hair was all messed up. His eyes were glassy. I could see stains on his clothes, and I could smell his overwhelming body odor. It looked like he'd been in the car for days.
So what'd you do after seeing all this?
Well, it was just a routine traffic stop. So I asked Mr. Ray for his license and his registration.
How did Mr. Ray react?
Well, he got all antsy, and he asked me why I needed them. When I told him it was just routine, he tried to tell me he had forgotten his wallet at home and that he didn't have his registration either.
What happened next?
Well, it was clear he had no idea what he was talking about. I mean, his wallet was sitting right there, right out in the open, right in plain view.
So what'd you do after seeing this wallet in plain view?
Well, I pointed it out to him. He finally ended up taking out his license and registration, and eventually he gave me both of them.
What happened after this?
I started walking back to my squad car to run the information on his plates. On my way there, I just happened to glance through his front and back windows.
Let's focus in on what you saw, Officer Wentz. What'd you see through that front window?
Well, there was trash all over the passenger seat.
What about the back window?
It was also a mess, but for a very different reason.
Officer Wentz, I'd like you to take a look at page 99, exhibit 22 in your electronic binder. Do you recognize what you see?
Yes, I do.
What is it?
This looks like the back seat of the defendant's vehicle.
Is that a fair and accurate depiction of what you saw looking through the back seat?
Yes, sir. Looks like it.
The defense moves exhibit 22 into evidence.
Any objection?
No objection, Your Honor.
Without objection, the Exhibit 22 is received.
Permission to display on screen for the jury.
You may publish.
Officer Wentz, can you tell the jury what you saw?
Sure. You can see here there's a dirty shovel, a couple of bleach containers, and there on the car seat there's several large trash bags. They were all sitting out there in the open, just like the wallet was.
Thank you, Mr. Hitchcock. You can take that down. Well, let's go back to the traffic stop. What did you do after seeing all this stuff in the back seat?
Well, I went back to my partner's car to run the license and registration. That would tell us who the person was and if there were any active warrants out.
What happened next?
Well, I went back to continue talking with Mr. Ray.
How did Mr. Ray react when you got back?
He started yelling, "Are you with the CIA?" I said, "No, obviously," but he kept yelling that he knew the CIA had been watching him because they thought he was a terrorist. He said he could hear the sirens of the CIA.
Officer Wentz, what did you do after hearing all this yelling about the CIA?
I told him this was just a routine traffic stop.
Objection, hearsay.
What is the hearsay, Ms. Wilkinson?
The hearsay as to this witness saying what he said to the defendant.
The witness has first-person knowledge, right? What is the truth of the matter that he's asserting? Ms. Wilkinson?
Oh, sorry. What he just said.
Mr. Barrett, restate your question, please.
Yeah, of course. I asked Officer Wentz, what'd you do after hearing all this yelling about the CIA?
Ms. Wilkinson, do you have an objection to that question?
Your Honor, I was objecting to the witness's response. Sorry.
Okay, and the response was?
I could offer that. I think he said I told Mr. Ray it was a routine traffic stop.
Okay. And the basis of your objection, Ms. Wilkinson, is?
That they're offering this for the truth of the matter.
What truth? That's a routine traffic stop?
Okay. Your Honor, we take back our objection. Sorry, I think I misheard.
Okay. It's a technological difficulty for sure. So your objection is withdrawn. Thank you, counsel. You may proceed.
So, Officer Wentz, to be clear, what'd you do after hearing all this yelling about CIA?
Well, I told him it was just a routine traffic stop. But because he was yelling and getting belligerent, I actually asked him to step out of the vehicle.
Did Mr. Ray comply?
Eventually, but he kept asking me for my CIA credentials. Again, I told him I was just a police officer, even showed him my badge. And then he got out. But after he got out, he changed again.
What do you mean changed?
Well, before he was frantic, but when he got out of the car, he started moving really slowly. I had a complete blank stare and wouldn't make eye contact with me at all. Then he started talking in this monotone voice, not to me, more like to himself.
What was Mr. Ray saying?
Well, he kept muttering to himself over and over again. Then he looked at me like he hadn't noticed me before and just kept saying, I was just trying to get my son in shape and get him to admit what he broke. My son just needs to do jumping jacks.
What happened after you heard all this about the jumping jacks?
Well, then he started doing a jumping jack. I told him to stand still, but it didn't seem like he heard me. He started doing another and another. At this point, I had no idea what he would do next, so I actually pulled my gun and I yelled at him to stop.
Did he stop?
Well, he stopped doing jumping jacks.
What happened after he stopped doing jumping jacks, Officer Wentz?
Well, he covered his ears and started moving his head uncontrollably. I was finally able to pry his hands from his head and get his handcuffs on. But then he started speaking in that same low, monotone voice.
Officer Wentz, what did you do after seeing all this?
Well, at that point, my partner called me over. So I sat Mr. Ray down on the curb just a few feet from our patrol car. My partner said the plates had been flagged for a missing child report. So I had my partner keep a really close eye on Mr. Ray, and I went to radio it in. I described what happened to dispatch, and I expected them to send an EMT.
Who'd they send?
Well, about 20 minutes later, Detective Booth arrived on scene.
What did Detective Booth do when he arrived on scene?
It was strange. Well, Detective Booth told me to escort Mr. Ray to the station and get him set up in an interview room for an interrogation right away. I thought there would be an EMT called in so we could get him to a hospital.
Officer Wentz, what did you end up doing?
I followed orders. I put Mr. Ray in the back seat and then drove him to the station, then straight to the interrogation room, just like Detective Booth told me to do.
Thank you, Officer Wentz. Nothing further, Your Honor.
Thank you, counsel. Ms. Wilkinson for cross?
Yes, Your Honor. Officer Wentz, at the time of the arrest, you had only been on the force for 2 years, correct?
That's correct. Yes, ma'am.
You were a rookie at that time.
I like to think of myself as a little more experienced than someone first on the job, but yeah,
You typically work traffic stops.
that's correct. Yes, ma'am.
An exciting night for you is a couple of DUI arrests.
That's correct. It's not super exciting out on traffic.
You've never investigated a murder.
No, ma'am. That's for the detectives to do.
You don't hold a single degree in psychology.
No, I do not.
You've never even encountered a mentally ill suspect.
Well, I'm not sure about that. Sometimes I don't know for sure, but I can't say for absolute certainty if that's what you're asking.
Right, Officer Wentz, you don't know if you've encountered a mentally ill suspect.
I can't be sure, no.
Now, let's talk about your work here in this case. The defendant stopped at your sobriety checkpoint on October 19th, 2018.
I believe it was October 18th.
Is it your testimony, Officer Wentz, that the defendant stopped at your sobriety checkpoint on October 18th?
No, I think it is the 19th. I'm sorry, that was 2 years ago. I believe it is the 19th.
You approached his window and you asked him for his license.
Yes, I did.
He wouldn't give it to you.
No, not at first.
He said he left it at home.
That's what he said first. Yes, ma'am.
He lied to you at first.
Yes, he did.
You saw the defendant's wallet on the center console.
That's right. It was just sitting there. That's why it was so weird.
After you noticed that it was just sitting there, then the defendant handed over his license.
That's correct.
And officer, as you were on your way back to your squad car with that license, something caught your eye in the defendant's back seat.
That's right. It's standard procedure to look through a traffic stop individual's backseat just to make sure there aren't any weapons or dangerous items.
Right, and you saw a dirty shovel when you did that.
Yes, I did. Not necessarily a dangerous weapon, but it certainly piqued my interest.
Well, the dirty shovel looked like it had blood on it. Isn't that right?
That's right. I couldn't be sure at the time, but that's what it looked like.
You also saw jugs of bleach
Yes, I did.
and large black trash bags.
Absolutely. Those are the 3 items I saw.
At that point, officer, you knew that you couldn't walk away from the defendant.
Well, I did walk away from the defendant momentarily, but I returned.
Right, when you momentarily walked away, you gave your partner his license so that you could keep an eye on him. Isn't that right?
That's correct.
Because he had too many suspicious items in his car.
That's right. It's not my first day on the job. I know when to keep an eye on someone.
You were afraid that if you walked away, the defendant would flee.
It's always a possibility in a traffic stop. I mean, they are in a vehicle, so I wanted to keep an eye on them.
After you noticed the items in the defendant's back seat, his behavior changed.
I would say so, yes.
Suddenly, the defendant no longer knew who you were.
That's right, yes.
Objection, Your Honor. Speculation, if I may be heard.
I'll hear you for a second on that. Why do you think it's speculative?
Just the phrasing of the question. The opposing counsel said the defendant no longer knew who you were, as opposed to it didn't seem like the defendant knew who you were.
Ms. Wilkinson,
This officer.
I'm going to interrupt you. Ms. Wilkinson, for the sake of the clock, would you be willing to rephrase?
Yes, Your Honor.
Thank you.
At this point, the defendant thought you were a member of the CIA.
That's correct. That's what he said.
But by this point, officer, you had already identified yourself as a Skelton police officer.
Of course. That's what I did when I first approached his window.
After you saw the shovel, the defendant starts talking about the CIA.
That's right. After I returned from dropping off the license.
He didn't accuse you of being CIA when you first approached his vehicle.
Not that I remember, no.
Then you asked the defendant to step out of the vehicle.
Right. He was yelling and shaking, so I wanted him to get out of the vehicle so that I could make sure that I could control him.
Let's talk about when the defendant got out of the car. His behavior changed again.
Yes, it did.
He was moving slower.
Much slower.
He had a blank stare on his face.
Yes, he did.
At that point, he couldn't even look you in the eye, could he?
No, whether he couldn't or wouldn't, I didn't know, but he certainly wasn't making eye contact.
He said, "I didn't mean it."
That's right. That's one of the things that he said when I could finally understand what he was saying.
But that's not the only thing he said, officer.
No.
He said, "I messed up." Isn't that right?
That's right. That's one of the other things that he said.
Now, let's talk about the ride to the police station. Once again, the defendant changed his demeanor. Isn't that right?
You mean from when he was first taken out of the vehicle?
Well, at that point, he became calmer.
Yes, marginally in the car, yes.
So that's a yes, officer. He became calmer.
Yes.
And he remained calm until he was placed into the interview room.
Well, there were some intermittent episodes of crying, but I would say on the whole, yes, he was calm.
He remained calm until the detective walked in.
That sounds right. Again, intermittent crying, but not yelling or screaming.
When Detective Booth, the homicide detective, walked into the interview room, the defendant became a totally different person.
His demeanor changed a little bit. I don't know that I would say he became an entirely different person, but you're right. He changed a little bit.
Officer Wentz, is it your testimony that he didn't become a totally different person at the end of the night in the interview room?
Well, I mean, his demeanor changed and his behavior changed. He didn't create an alter ego or anything.
Officer Wentz, you gave an interview to Detective Booth right after the arrest, isn't that right?
That's correct, yes.
Right, and that interview was on October 23rd.
That sounds right. About a week or two after the arrest.
And officer, in that interview, you told Detective Booth, in your own words, that the defendant became a totally different person.
Object, Your Honor. Hearsay may be heard.
Sure. What's the truth of the matter that's being asserted from the hearsay?
Well, Your Honor, I object hearsay just to state that this is an improper impeachment. It may be heard on those grounds. I might have mischaracterized it.
I'll let you tell me. Yeah, go ahead.
Yeah, of course. During the direct examination, Officer Wentz testified that there was this change of demeanor and was agreeing with opposing counsel. Now, just because he didn't say became a totally different person, he was agreeing with the substance of that statement he made during the interview with Detective Booth. Additionally, this is just an interview between two officers. It's not prior testimony. It's not a deposition.
I'm going to overrule you based on the improper impeachment objection, and we'll carry on. So, Ms. Wilkinson, please continue. Okay, thanks.
Officer Wentz, when Detective Booth, the homicide detective, walked into the interview room, the defendant became a totally different person. Isn't that right?
Yeah, his demeanor changed, his behavior changed, but it wasn't like he was inhibiting an alternate personality or anything.
Nothing further, Your Honor.
Thank
No
you.
redirect, Your Honor.
No redirect?
No redirect. May the witness please be excused?
The witness is excused and not subject to recall. Thank you very much. Officer Wentz, you may step down. Does the defense have any other witnesses to call?
No, Your Honor. We do not. With that, the defense rests.
Very well. Defense rests. Are there any motions?
Not from the defense, Your Honor.
Very well. Is both sides prepared for closing arguments? Are both sides prepared for closing arguments?
Yes, Your Honor. Can I just have 2 minutes to fill up my water bottle?
We might do better than that if we can. How about a time check? Are we prepared for a time check, or do the timekeepers need a minute or two to collect that?
Yes, we need to confer.
Okay. Why don't we take let's give ourselves a little bit of luxury. How about 5 minutes? And we'll be back at looks like I can't see that far. Oh my God. 43. All right. Plus 5 gets us to, I think, what is that? 50. What is that?
48, Your Honor.
48. See, I'm good thing I didn't go to medical school. Thank you guys. 48. Thank you. Okay, do we have all counsel here? Back and refreshed, ready to go? Okay, great. Is the state ready to proceed with closing argument?
Yes, Your Honor.
Fantastic. Why don't we start with state, and you may proceed when you're ready.
May it please the court, counsel, ladies and gentlemen of the jury. The last thing 6-year-old Nathan saw while he was alive was his dad, the person he's supposed to trust the most, standing over him, squeezing and tightening a belt around his neck, pulling until Nathan stopped crying, stopped screaming, stopped moving. Members of the jury, you've been brought here today to bring Nathan the justice he deserves, to hold the defendant accountable for killing a boy who had no fighting chance against a man. Ladies and gentlemen, when these arguments conclude, His Honor will instruct you on the law. He will tell you that we had the burden to prove to you today, beyond a reasonable doubt, that the defendant caused the death of Nathan Ray with malice aforethought. Now, ladies and gentlemen, malice aforethought. All that means is that we have to prove the defendant intentionally killed Nathan. And make no mistake, ladies and gentlemen, the defendant intended to kill his son. Let's take one last look at the evidence to see why. Today, you heard from the lead detective on Nathan's case, Detective Booth, and he took the stand and told you the defendant confessed to killing his son. And members of the jury, we now know how. 6-year-old Nathan was put through a rigorous military-style punishment. He became exhausted. He couldn't keep up. But the defendant wouldn't just let it end there. No, instead the defendant sat on his bed and thought about what to do next. Then he grabbed a belt, tied it around Nathan's neck, and pulled until there wasn't a single last breath to pull out of Nathan's body. And ladies and gentlemen, you heard how the defendant tried to cover up the crime after he committed it. You saw what the defendant searched on Google the day after he killed his son. Countries that don't extradite for murder charges. How to get rid of a body. Will bleach destroy a body? Then, the defendant drove to a secluded area, stuffed Nathan's body in a garbage bag, throwing Nathan's body out like a piece of trash, trying to hide and bury the heinous crime he committed. But ladies and gentlemen, we know the defendant didn't just confess to Detective Booth. He confessed to Officer Wentz, the defendant's own witness too. He said, "I messed up. I didn't mean to." Now, speaking of Officer Wentz, the defense wants you to believe that what Officer Wentz saw were the actions of an insane person. But members of the jury, we were all here today. We heard when Officer Wentz was questioned. He may have seen the defendant acting strangely, but what's important is when this strange behavior occurred. Today, you heard Officer Wentz testify that when he first approached the defendant in his car, the defendant lied to him, told Officer Wentz he didn't have his ID, even though it was sitting right next to him. Only when the defendant was forced to identify himself, only when Officer Wentz saw the bloody shovel, trash bags, and bleach, the defendant changed his demeanor again. All of a sudden now he's asking about the CIA. And when the homicide detective walked in, well, the defendant became a totally different person. Ladies and gentlemen, these are not the actions of a mentally insane person. These are the actions of a cold-blooded killer, desperate to try and save himself and cover up the crime he committed. But ladies and gentlemen, we now know the defendant killed his son. we know he sat on his bed. We know he had time. Had all the time in the world to make the right decision. But he didn't. The defendant killed his son on October 17, 2018. Now keep in mind the timeline of the defendant's strange behavior. The behavior that the defense wants you to look so closely at. This strange behavior only started after the evidence began to build against him. Now, I expect the defense will try to convince you that the defendant is insane, but remember what you heard here. Keep in mind the timeline of these symptoms. You heard from Dr. Mac LaGreca, an expert in forensic psychiatry. And today she told you that the defendant never exhibited symptoms of schizophrenia. In fact, the defendant was malingering, faking symptoms of a mental illness in order to avoid the consequences for killing his son. No doctor prior to Major Riley ever diagnosed the defendant with schizophrenia. And because Major Riley was the only one to testify today that the defendant is schizophrenic, we have to ask ourselves, why? Well, after today, you know it's because now a child is dead. It's of no surprise that now the major wants to tell you her patient is insane. And that, oh yeah, she saw symptoms back in 2010 too. But members of the jury, you heard Riley on the stand today. She told you the defendant denied having hallucinations and that he denied having delusions. Major Riley is talking out of both sides of her mouth, just like the defendant. Don't fall for it, members of the jury. The defendant knew exactly what he was doing when he tied a belt around Nathan's little neck and squeezed until Nathan took his last breath. The defendant knew what he was doing when he searched for how to get rid of a body. When he stuffed Nathan's body in a garbage bag and threw him out like trash. Nathan was powerless against the defendant. But now, you have the power to do what's right. To tell Nathan that his life was worth more. To hold the defendant accountable for killing his son. Return with the only verdict that is consistent with the law and supported by the evidence. Find the defendant guilty.
Thank you very much, Ms. Brill. I made a mistake before we started with Ms. Brill. Can we get the time check, please?
Your Honor, would you like Ms. Brill's remaining time
Yes.
as well?
Yes.
Okay. I have the defense with 12 minutes and 39 seconds remaining, and I have Ms. Brill with 1 minute and 11 seconds remaining.
Okay, we'll offer Ms. Brill 1 minute, 11-second rebuttal if she would like it. And meanwhile, we'll have Mr. Hitchcock's closing argument. And incidentally, everyone should be in the proper view. Wait a second. Speaker view. Switch back to speaker view. Okay. Sorry about that. Thank you, Mr. Hitchcock. Thank you.
They missed the signs. Timothy Ray is in a waiting room. Again, same curtains, same clock, same problems. The voices, the negative thoughts, the family issues, it's becoming unbearable. He knows something isn't right. It never has been. He just doesn't know what. He hopes maybe this doctor will finally give me an answer. But an hour later, he leaves without one. Year after year, Mr. Ray sits in another waiting room, sees another doctor, books another appointment. But year after year, there's no treatment, no diagnosis, and no answer. And his problems don't just go away, but they get worse. And eventually it's too late. Mr. Ray's schizophrenia took over. Nathan is gone because they missed the signs. Now, today, the state has charged Mr. Ray with murder, and normally the burden would be on the state, but we aren't disputing what happened to Nathan today. Instead, this case comes down to our affirmative defense of insanity. This defense exists because sometimes people do horrible things, but because of mental illness, they don't realize what they've done. So while the law says there must be consequences, those consequences aren't criminal. Now, with this defense, we had a burden, but it's not the burden you might be familiar with. It's not beyond a reasonable doubt. Our burden is the much lower standard of clear and convincing evidence, simply meaning much more likely true than not. And to prove our insanity defense, we had to show two things. One, that Mr. Ray has schizophrenia, and two, that schizophrenia caused Mr. Ray to lose control and harm Nathan. I'll take those one at a time. First, we've proven that Mr. Ray has schizophrenia. Dr. Riley, the only medical professional you heard from who ever actually met Mr. Ray, testified under penalty of perjury. She is confident he is suffering from schizophrenia. And we heard the reasoning behind this diagnosis. While a diagnosis of schizophrenia is medically sound if someone exhibits just 2 symptoms in the DSM for a month, Mr. Ray had been exhibiting 3 symptoms for years, some dating back to his childhood. He would have negative symptoms, strange and erratic behaviors, locking himself in the bathroom, changing his mood at the drop of a hat. He would have delusions, paranoia about a conspiracy between his wife and his son to hurt him and to leave him. And he would have hallucinations, seeing strange shapes in the world that weren't really there, and hearing voices telling him to do horrible, horrible things. The state wants you to believe that you can't trust Dr. Riley, that she's just some hired gun. But comparing her to the work that the state's expert did in this case, we could tell that's very far from the truth. Her investigation was thorough. Clinical interviews, the best practice in the field and something the state psychiatrist never did. She reviewed every piece of evidence in this case, and if that's not enough, she conducted 3 more interviews with people who know Mr. Ray well. His wife, detailing years of antisocial behavior. His boss, erratic mood swings at work. And his father, the family history of mental illness, all corroborating that Mr. Ray's symptoms before killing Nathan are real. That's how we know that his symptoms from after the killing are those of schizophrenia. You heard from Officer Wentz about CIA accusations, erratic head movements, talking to himself, and jumping jacks at a traffic stop. You heard from Detective Booth. According to her, nothing odd happened in the interrogation, but you saw for yourselves that wasn't true. Again, with CIA accusations, this time bringing up the voices. They told me to, without explanation. And then again with Dr. Riley. Government agent accusations, conspiracy about the life, the voices. In that interview, Dr. Riley finally saw the signs that Mr. Ray's behavior isn't normal because Mr. Ray isn't normal. He's schizophrenic. This brings me to my second point, that on the day Nathan died, Mr. Ray's schizophrenia was so severe he didn't know right from wrong. A moment ago, the prosecution came before you and reminded you of the gruesome and horrific details of Nathan's death. How a loving father suddenly did the unthinkable by using a belt to strangle his son, all over spilled juice. Members of the jury, I bring this up because these details are tragic and shocking. But that means that they're also evidence that Mr. Ray was insane. Because sane people don't kill their kids. Remember, there's no history of abuse, no desire to harm. No, instead, Mr. Ray was trapped in his own mind. Hallucinations, delusions, paranoia, it caused him to lose control. Now, the state brought you some Google searches, and they want you to believe that these show he knew what he was doing was wrong when he killed his son. Except they don't. Because these Google searches happened the day after Nathan died. Think about that for a moment. Why would Mr. Ray commit a heinous crime that he knew he'd be the obvious suspect for without thinking about how to get away with it beforehand if he wasn't insane? He wouldn't. All these searches show is that he realized what had happened after it was too late. Now, you may be thinking, this doesn't make sense. How can someone be insane one moment, then realize what they had done, and then experience more symptoms? But members of the jury, that is exactly why this defense exists. Because Mr. Ray hops in and out of schizophrenic episodes based on triggers no normal person can understand. Schizophrenia isn't supposed to make sense to those of us who are lucky enough not to suffer from it. That it's the disease that chooses when to be in control, not the person. Today, the prosecution accused Mr. Ray of malingering, claiming that he's faking his symptoms. Their expert who came to that conclusion, Dr. LaGreca, well, she didn't treat Mr. Ray, didn't meet Mr. Ray, never even saw Mr. Ray's symptoms for herself. You heard that on cross-examination. Never even been in the same room. In fact, none of us get the chance to see his symptoms. We could have. There was a recording, but we don't have it because the detective decided not to preserve it. She chose to let it get deleted. Why would she make that choice? If someone had just confessed to killing somebody, wouldn't you want to keep that evidence? So ask yourselves, what was in that recording? No, really, what would it show? Was Mr. Ray screaming? Was he crying? Moving or shaking? Where was he looking? Did it seem like he was talking to someone who didn't exist? We'll never know. Well, why would the detective not want you to see this for yourself? On cross-examination, she admitted, I can preserve all the evidence I want. It's because she saw the signs. She knew Mr. Ray was insane, but because she thought Mr. Ray is a piece of shit who would be better off dead, that's right, quote, a piece of shit who would be better off dead. She couldn't let you see the signs for yourself. Members of the jury, I want to make one thing clear. Finding Mr. Ray not guilty by reason of insanity isn't some magical get out of jail free card. Instead, it just means making sure Mr. Ray receives the treatment he should have received long ago if doctors hadn't missed the signs. Convictions are for people who do wrong and mean it, guilty hands and a guilty heart. But Mr. Ray isn't evil. He's sick. And while there may be blood on his hands, there isn't evil in his heart. Mental illness is not murder. Members of the jury, this is the jury verdict form. In a few moments, you'll leave here and begin your deliberations in this case. And when you do, we ask that you choose to treat Mr. Ray for his disease, not punish him for being sick. We ask that you find him not guilty by reason of insanity. They miss the signs. You don't have to. Thank you.
Thank you very much, Mr. Hitchcock. Rebuttal?
Yes, Your Honor. That's it, ladies and gentlemen. They missed the signs. That's their case. Members of the jury, I'll tell you why the signs were missed. Because there were no signs until after the defendant was arrested, until after he was forced to identify himself to Officer Wentz, until after he was questioned by Detective Booth. Members of the jury, all these symptoms that the defense is talking about, they were never reported until the evidence started to build against the defendant. Members of the jury, this is no coincidence. You heard Dr. LaGreca on the stand today. She told you why he's doing this. Because he's trying to avoid the consequences for killing his son. Ladies and gentlemen, hallucinations, delusions, negative thoughts, those things didn't tell the defendant to kill Nathan. The defendant intentionally strangled Nathan on October 17, 2018. Return with the only verdict that is consistent with the law and supported by the evidence you heard today. Find the defendant guilty.
Thank you very much, Ms. Brill. Thank you very much, counsel. I'd ask the judges to submit their ballots at this time. The case is submitted. Ask the judges to complete their ballots and get those submitted. And everyone, please stay put while that's happening. And once we get an all clear from command center, then we'll have very, very short, brief, succinct comments for the advocates, and then we'll get you all on your way.
Judge, I'm sorry. Can I just get the team's numbers? I don't believe I ever got them.
Of course. The prosecution, what is your team number?
Let me double. I believe we're 106, but yeah, 106.
Okay, defense?
I believe we're 108.
108. Very good. Okay, so unless there are any other administrative matters, we'll just sort of hang tight and let the jurors get their ballots in. And then once we have that reported, we'll go from there. And there we go. If the scoring jurors would be kind enough to let me know when they have submitted all of their ballots, please.
I'm submitted. Di Giuseppe.
Thank you.
Mine is in as well. I'm Booth.
Thank you. Not to be confused with Detective Booth. Thank you, Juror Booth, for that.
As did I.
Okay, do we have everybody in then? Terrific. I will. Okay, we have received the quote green light. So if we'd have everyone come up on gallery view, I would appreciate that. And I first would like to congratulate the advocates on what was no doubt an exciting and very excellent demonstration of incredible advocacy by two incredibly capable and phenomenal teams. Well done to everyone, the witnesses too. And with that, I'll pass it over to perhaps Juror Rock, and we'll make him go first. And if he has any comments, please keep it brief. Thank you.
Yes, certainly. Good evening, everyone. So my name is Timothy Rock. I'm a Drexel alumni 2020. I was on their trial team for a couple of years. I just want to say that you guys were phenomenal. I was completely blown away. I know you guys have been doing this as the third round now, so you probably heard that, but you guys were absolutely top notch. I only really have one comment, and it's that a couple of times throughout the trial, it seemed like some of the advocates were interrupting the judge in the middle of objection arguments. It just doesn't come off very well. So just let the judge finish. You know, sometimes, you know, you want to get your point out there, so it seems like you're going to bite at it, but it just doesn't come off very well. So otherwise, I thought everyone across the board was stellar.
Thank you very much, Mr. Rock. How about Mr. Booth? We'll let you bat second, and we'll have Ms. Giuseppe bat cleanup. How's that? So.
Great. Hi, guys. I'm William Booth. I am also a Drexel alum, also 2020, also was on the trial team. Actually, Tim Rock and Sam, we were all on the same trial team. So you're going to hear the same stuff.
Nice.
I thought you guys were phenomenal. You guys were really great. Minor tweaks here and there, but that's all going to be style and preference stuff. The one thing I did see, and I think it has more to do with the Zoom courtroom than anything, facial expressions. Your face is so much bigger in a Zoom courtroom when there's only 4 people than if you were at counsel table 20 feet away or 15 feet away. So I think every single person had a reaction and that I noticed. So just keep on top of that. Again, small nitpicky stuff because you guys were so good, and good luck with the rest of the competition.
And we'll hear from the certainly least, but certainly not the last, but certainly not the least Drexel gang that's all here. So that's terrific. I'm so glad you guys all are participating. Ms. Di Giuseppe, please.
Hi, guys. I just wanted to say, first off, you've heard it multiple times now. This was an excellent round. I think watching these on Zoom, it's simple or easy to glaze over. And I felt in this round, I was fully engaged the entire time. I thought it was so entertaining. I really don't have much negative comments to be honest. And I don't even want to waste comments on your content and your structure because both sides, your cases were so well thought out. Your content was incredible. I seriously do not have much criticism. I was going to make a comment about facial expressions too. Mr. Booth took that, with the exception of Mr. Barrick. Mr. Barrick, I didn't see any facial expressions from you, but everybody else at some point made like a nasty face or rolled their eyes. I know when you're in a good round like this, you get passionate because it's intense, but you need to be careful because it's distracting and it doesn't come off well. One other point was, and I think this goes mostly to Miss Brill and I can't remember, Mr. Hitchcock maybe. At some point, the both of you argued after the judge ruled. I know that some attorneys actually have different opinions on this, but I've been taught when a judge rules, that's their ruling. And it is, you don't want to try to convince them otherwise, and it doesn't look good. So if a judge issues a ruling, you're not going to change their mind. Save your words. Someone once said to me after a mock round, just because you talk more doesn't mean your argument's better or something like that. And it was a cutting remark, but it's the truth. I actually have kind of an opposite comment from Miss Wilkinson. So at one point, during the trial, you objected to hearsay. It was a nothing comment. Would I have objected to hearsay? No. Technically, were you right? Actually, I think you were. And you got a little bit of pushback from the judge and from opposing counsel, and you immediately withdrew and you kind of turned inward. If you think you're right and you have an objection, you need to be confident. And you need to stand firm in what you think, because you're an excellent advocate. You are incredible. And don't let somebody make you think that your objection's wrong just because you get a little bit of pushback. You're going to get a lot of pushback. So stay firm in what you think. But for the most part, this was a really tough round for me to score. I think both teams are amazing. I don't know how the scoring works, but I hope you both advance, and I wish you both a lot of luck.
Thanks very much. I'll go really fast. Hi, I'm actually Aaron Pease. I'm a trial lawyer, civil trial lawyer. So I'm outside of my realm with the criminal, or as I call it, criminography. This is not my lane. So my errors in adjudicating the case are mine. I'll say that first. Second, I am also a mock trial and moot court alum, national champion mock trial, national champion moot court. I only mention that because I definitely can empathize with the pain that goes into the incredible amount of work that you guys obviously have done. And you do the profession credit by dedicating yourself so much in preparation. I've met a lot of lawyers that are smarter than me. I've met very few that are as prepared as I am. And that's something that you need to think about. I will leave the discussion. You have three of the five of us attorneys on this call with you talking about when the judge makes the decision, that's it. I'm number 3. I will leave it there. That's 3. That's a majority. Please take that to heart. This is one of the times you take it and you say, okay, and you move on. That's it. I really appreciated and was very delighted to see the level of conviviality between the council here. And I want to encourage you to continue to keep doing that. Part of the reason why this is, look, that doesn't take anything away from how hard you fought, right? And to Ms. DiGiuseppe's point, look, you guys have to preserve a record. So if you think you're right, stay in the fight, okay? You must preserve your record. And it's okay to say, Judge, listen, I know I'm sitting here in the fetal position of battered pulp, but the truth is I got to make my record, and that's why I said it. And then no one's going to give you any shit about that, okay? So that was just food for thought, but I was very glad to see the level of conviviality, and I'm grateful for it. We sometimes, in our ardent, zealous representation of our clients, sometimes we lose sight of that. So I encourage you to continue to do it. Well played, well done. Very good. So I think, oh wait, I have to read stuff. All the ballots have been submitted. Thank you, everyone. Unless there are any last questions from council advocates or judges, then we're going to let you out of here.
Thank you so much for judging.
Thank you, guys.
Good luck, guys.
Thank you, guys. Good luck.
Good luck, guys.
Go Drexel.
Definitely.